हेलो सर, वॉइस में वीडियो क्लियर दिया? हेलो हेलो
ಸರ್ ಕ್ಲಿಯರ್ ಇದೆ.
ಸರ್.
ಎಸ್ ಸರ್.
I don't want this.
No, no, no memo for hearing, Mr. Please. No memo for hearing now. Take it that it is admitted. What is it? We will admit it right now. Call it just now and admit it. Fine. It is admitted. There are only no, so you wake up only when 10 days are left for vacation, right? What were you doing from January when it was heard? Who heard it? When? Huh? So after, no, so after 1 week you have woken up all of a sudden. Not possible, please understand. How many days are there, tell us. I think you are not the right person to begin with. Yes, Mr. A day after. All. Yes. Fresh matters. Give, yes, fresh matters, give all. No. Not, we can't, by a mention memo, we cannot list hearing, we cannot hear the case like this. File an application for urgent hearing. See, Mr. In these memos, only fresh matters will be taken up. Otherwise, it will not come up. Only fresh. Fresh. Give whenever you want.
But the fresh matter, matter pertains to imposition of property
You
tax.
have given.
But tomorrow,
Whatever date you have mentioned, it will come up, right?
tomorrow, because there is an apprehension of closure of the school by the people.
No, we are. You are written tomorrow, right? Granted. Yes.
Number 1.
Yes, madam. So serial number 1, 2 weeks time is granted to comply with office objection.
Number 2, CLS Sankara Krishna.
2 weeks time.
Number 3, Srikanth Venkateshwar. Number 4, MP Geeta Devi.
It counsel for the appellant submit that the needful has been done. Office to verify and proceed. Needful has been done today. Office to verify and proceed.
Number 5, CH-2 Prakash.
My lord, during the course of the day, I will furnish the PF letter.
2 weeks.
Always.
Sri Joseph Anil Kumar. Number 7, Sri Shankar Narayan Rao Devi.
2 weeks.
Number 8, Sri Siddhappa BM.
Then it counsel for the appellant submits that the needful has been done today. Today office to verify and proceed. Yes.
9, Sri Gurudat BS.
2 weeks time.
10, Sri Murali Krishna Care.
2 weeks.
Number 11, Sri MP Geeta Devi.
2 weeks.
Number 12, Sri Bachchan. Number 13, Sri Vitul DA. 14, Sri Ajay Kumar M. Number 15, Sri Shekhar L.
2 weeks.
Number 16, Sri Ramana MVV.
2 weeks.
Number 17, Sri
The
Manjunath Ji.
appellant, your lordship, 3 weeks time may be granted, your lordships. Some translation is also there.
18, Sri Vani Krishnania.
Appearing for the appellant, my lord, 2 weeks time may be granted.
Number 19, Sri
What is
Tata, Government Advocate.
1 day? 19 you give Mr. EBS corpus. What is it?
Service is away.
Service is awaited.
R2. R2. Who appears for ED?
So yes, let steps be taken for
Standing. Who appears for ED? Huh? Petitioner.
3 weeks, 3 days.
Number 20, Sri Vinod Kumar BN.
Counsel for the appellant submits. Needful has been done. Office to verify. Yes. Supreme order, if any, shall continue.
Number 21, Sri Rangram Movie. Hearing RIS number 22, Sri H.J. Bhaskar Babu, Sri V.P. Shivkumar, Sri Sri Prasad Payas.
Why 2007 matter? If you don't appear, what will happen? So previous date also you didn't appear on that 31/1 also you didn't appear. What should be done? I think you own now on yourself, right? But why you didn't appear on the previous date also? Nobody knows, Mr. This is your self-serving statement. But we have objection, right? Opposite party can't restore it. Ask them to restore, pass an order and give it to them. We are asking, we have to pass an order of restoration. We are asking. You can't get away by saying opposite party has no. So let him or her restore your appeal and get the copy and send it to your client and argue before him or her. This 2007 matter, Mr. 14 years, the client must have forgotten about it. And thereafter also 3 years have passed. 2019 it was dismissed. 3 years have passed. The client must have forgotten everything about the case. Don't trouble him. You know what we are telling you, that party must have forgotten everything about the case. Don't trouble him by restoring it. Counsel, we are recording a statement. Learned counsel for the appellant submits that the dispute between the parties have been amicably resolved, and the parties and the appellant shall produce the terms and conditions of the settlement deed in view of a forces submission order dated 31st January 2019 is recalled. In the result, MFA number so and so 2194 of 2007 is allowed.
Is there any settlement?
He says it is settled. Settled. So then learned counsel for the parties joint. Therefore, MFA is restored, IA is allowed. If file appeal is confirmed with the result IA 1 of 2019 is allowed. What is it? Appeal is admitted for hearing. Appeal is admitted for hearing. Record.
Number 20.
We have condoned the delay, admitted the appeal for hearing. It will be heard.
24. The
Paper for memo file is accepted for publication. Yes.
Number 25.
Not password. No, nothing. You are senior. Memo for acceptance of paper publication. No senior is required. No senior will appear for this. You have to appear. We are accepting this. What senior will do? You got the newspaper, right? So then we are accepting it, Mr. What is that? Why should you seek an adjournment? What is this IA 2 of 22? You are appearing, Mr.
Next matter.
Next. What is IA 2? Action. What is it?
Including service. Regarding service.
All right. So IA 2 of 22. Notice issued. Notice for service of notice on respondent has been published in daily newspaper. Which newspaper?
Three newspapers.
Which newspaper, Mr.?
Bangalore edition.
Bangalore edition, as well as
Bangalore City edition.
Bangalore City edition.
Janmabhoomi Parsi edition.
What IA 1 of 22, 2 of 22 is allowed. The memo filed for service of notice is accepted. So it is admitted, the appeal is admitted for hearing record. What IA 4 of 21 LR? Will allow it. It's covered, right? Madam, it's covered, right? Is it correct or not? Right? Yes. So that's why he's not appearing. Mr. Sabrat is also seeking adjournment in our court. All right. What's your name? Yes, fine. It's covered, right, madam? No, nothing. This is, we will record this submission. Sir, what Mr. Sabrat? No. This is appeal by the KIADB, right? Heard on IA number so and so. What is the IA number? 4 of 21. 4 of 21. After hearing learned counsel for the parties, the same is allowed. Let amended cross title be filed during the course of the day with consent of the parties. Heard finally, this intra-court appeal arises from an order dated 18th March 2021, passed in WP number. The order 12,000. Madam, see WP number. I am not getting the order. Page 9. I think. This they have facing sheet. That's all right. WP number 2580 of 2020. Learned counsel for the parties have fairly submitted that the controversy involved in the instant appeal is fairly covered by a judgment dated 23rd March 2022, passed by this court in WA number 557/2021. Full stop. In view of aforesaid submissions and for the reasons assigned by us in the aforesaid judgment, the appeal fails and is hereby dismissed.
26. Exercise 20.
Apply with office.
27. The supervisor counsel order. Government advocate CPL Sanjeev.
Yes. Oh, you have heard, right? You have heard what is going to happen in the case. Huh? That's why she is so eager. Before you could say something to the court, she intervened and said that she wants an adjournment. So you are appearing for madam. What's your name? Learned counsel for respondent market presence. Mr. Shetty along with Mr. Shiv Prasad Chandani Bodhar, learned counsel for the petitioner. Additional government advocate for respondent one. What's your name, madam? Learned counsel Praise for adjournment on the ground that arguing counsel is out of station. Next week, not next week, after vacation of 10 days, Mr. 10, only 10 working days are left. You don't know. Huh? So then what, how much we should hear? Huh? We don't know. We don't know what is the matter about virus, right? Huh? Huh? Right.
Statement of objections is filed already.
Suresh, we have to write the judgment. We can't say short point allowed. Huh? So, yeah. We wish that we had the privilege allowed of saying Mr. Shetty appears allowed. Huh? We can't do that. We have to write a judgment. Not possible. 3 days after vacation, list on 25th May.
But 28, the NN Damodar.
Learned counsel for the absent praise was granted 2 weeks time to enable them to take steps for substitution of LRs of disease. Respond number 2.
2 or 1?
1 or 2? 1. You said 2. 1. 1.
29, the MR Hiranagar.
Senior counsel. But what should he say? Senior counsel has been engaged. In the case is listed, the party engages senior counsel. That is adjourned. Case is adjourned. This is what to do. Sir, so we would like to tell you that senior counsel should not have accepted your brief. Once he knows that the matter is listed before court, he should not be an instrument of adjournment, right? He should not have accepted your brief. Place for adjournment on the ground that arguing counsel is out of station. This start.
Comment advocate, you are directed to find out whether the new committee has come into existence.
What are these?
What has happened, whether a new committee has been formed?
So you
But 30, Sharda Bandi.
They appear for the petition.
Government advocate is Sunendra.
The constitutional validity of the bylaws of the PBMP is questioned, by which the outdoor advertisement in the city of Bangalore is completely banned.
all right. How much time?
No, time was already given. What my kind
Then further paying 2 weeks time. 2 weeks time.
No, what I suggest is over 70,000
Mr. Verma, what we tell you is that only 10 days are left.
I respectfully agree.
Today, you told us you will take 2.5 hours in a matter. So where from we will get the time? Supposing if we start hearing, you will argue for 2.5 hours in this case, 2.5 hours in that case. Whole thing is we do.
This case won't take so much time. I assure you.
It's not possible. We are telling you, to be honest enough, it's not possible for us to hear everything. Like we are hearing your case, that case today. There is one habeas corpus. There is one matter in which ASGI appeared. How can we handle so many this thing? It's not possible before vacation. Mark Mr. Ravi Verma Kumar, senior counsel for the petition. Mr. Vikram Digol, senior counsel for respondent number 2. Praise fund is granted 2 weeks time. 2 weeks further time to file additional statement of operations list after entering summer vacation.
31, the Rayappa Valley, the road PSP.
Appearing.
Appearing for the petitioner in this matter, my lord. My senior is a bit unwell, my lord. May I request an adjournment to next week, my lord?
Vacation. No, but there's no stay, right? File contempt, they will immediately come rushing. He will get also well. It will function as a catalyst for speedy recovery. He will immediately recover. You get the contempt listed today, tomorrow he will recover. We are telling you. Go ahead. It's not the. If they are this thing, you know how to wake them up, right? Fine. Space for adjournment. On the ground that the arguing counsel, who is arguing counsel?
Mr. Rayappa Hadagali.
Is unwell. List after. File contempt. Don't wait. List after vacation. List after ensuing summer vacation. What? Get the do whatever you want to do.
32, C.T. Mahesh, Anu Fernandez, government candidate.
What memo filed by the appellant memo? What memo? We will accept whatever memo has been filed. Accept the memo, right? So, what is to be done now? This can't be heard like final hearing. This is 2021, Mr. This cannot. No. Fine. After vacation. No. See, we are hearing taking up 2011 and 12 matrimonial matters, and we don't see any justification for hearing these appeals merely because they are listed under preliminary hearing. If you are satisfied that it involves a substantial question, we will admit it. What is it? Preliminary hearing is only admission, right? Maybe for who will write the judgment? Will you write the judgment? Then we will list hundreds of matters today and close all of them, provided you undertake to write 25 judgments per day. So it's not possible, sir. Please. Everything is. This is 2021 appeal. Why it should be heard out of that? We will give you a date after vacation. Oh, fine. It's not possible, Mr. This side of the vacation, we'll take it up on 25th May. List on 25th May 2020.
33, C. Kitchen GS, C. G.R. Ravita.
It's been live streamed. Tell us it's being live streamed. I didn't realize. Exit. Is asking lawyer to write judgment. Fine. No, it's all right. Yes. Restoration. No, nothing much. Argue. Nothing. Know what is the case? The delay of 17 years will not become 1 year on Monday. It will remain as it is. You have to satisfy what is the explanation for the delay of 17 years in filing an application for restoration. That's why you are seeking an adjournment, right? Why? Simple question. No inconvenience. You are here. You are along with the file. You are present before the court. No inconvenience. Nothing. Argue. You know what is the case, right? Delay of 17 years will not become 1 year on day after tomorrow. It will remain same. No. Nothing. No, nothing. Tomorrow. It is the question is simple. There is a delay of 17 years. Tomorrow it will become 1 year. It will be reduced overnight. Yeah, you have to explain, right? Delay. Tell us what is the delay for, what is the reason for filing an application for restoration after a period of 17 years. Supreme Court has said it is covered.
I think not.
Yes. No, you have, don't say, Mr. This really irritates us. You don't have any right to not to agree. Why? You are bound by the decision so far as High Court of Karnataka is concerned. So that we don't need your certificate that you agree or don't agree. Don't agree. So you don't agree. So what? The order has to be passed by us, right? So don't tell us. I mean, yesterday also we have told the council. Don't tell us that you agree or don't agree. If you don't agree, go to Delhi. No, go to Delhi if you don't agree. If you agree, fine. Don't tell us. We don't need your consent. Fine.
In Ekati Ramlakshmi case and pleading Hinduja case, Lord, the facts of the Lord, the elimination had taken place prior to the act coming into force, Lord. Whereas in this case, Lord, the eliminations have taken place after the act coming into force. So I need to make distinction on those grounds, Lord.
Fine. Alienation has taken place after the act.
As in those two cases, Lord, in Ekati Ramlakshmi and pleading Hinduja case, Lord.
We got it. That we are noting it down. You see, we are noting down your submission. Yes. What else? This is the distinction we have noted down. What else?
1 day's opportunity. Tomorrow I have to work.
No.
1 day, Lord. My profound apologies. But my inquiries, the quality is not pleased. If you can take my humble request, can be 1 day's opportunity. Tomorrow I'll do it.
Praise God. So if tomorrow if you don't appear, it will be decided on merits, and no application for recall will be entertained on the ground that you are unwell and you are suffering from COVID. Fine. This tactic will not work. You have been unfortunate that it has come up before us. What can we say? You should have been more cautious in seeing that it should come up. Prays for adjournment and undertakes to argue the matter positively tomorrow. This tomorrow. Mr. What we are trying to tell you that you are an advocate and you are an officer of this court. Don't start begging around or merely for a case. We feel bad about it because we treat you on a much higher pedestal. You are an officer of the court. Don't, for the client's sake, don't beg like a beggar. Next week, tomorrow, what is there? You know what will happen. You know, don't be a beggar for the sake of your client. Your status is much higher. You are an officer of this court and an equal partner in the administration of justice. Understand? Don't behave like a beggar. Nothing happens. If you see, you can't help it. There is a delay of 17 years. You cannot make it 1 year overnight. There's nothing. You should have, you would have made an impression on this court if you would have fairly said, sir, there is a delay of 17 years, sir. I don't have a case, but my concession may not be recorded. We would have really respected you for your fairness. But this is not what it is. You are trying to just how somehow that this court dismisses on the ground of delay. So therefore, so somehow I will try to get the adjournment. That's what you have told your client. And you are blaming yourself that I am not prepared. No, not fair. This is all being live streamed. What impression will everybody is watching? We don't want to watch. What impression that you are begging before this court like a beggar? No, not fair. You are an officer of the court. This case is not your life. You will be handling so many cases as an advocate if you are sincere about the profession. Good. Losing a one case doesn't matter. You can't help it. The law is against you. Supreme Court is against you. We can't help you. These decisions bind us under Article 141, right? You know the fate. There's no point in getting what will happen in 24 hours. You tell us what, nothing will happen. Somehow you are thinking that one of the bench may not assemble tomorrow. Something earthquake will come. Something like that. Wonder. What? There will be a flood in the city of Bangalore. The High Court will be. flooded, nobody will enter like that. No, what will happen tomorrow? You know that there is a delay in making an application for restoration. The delay is of 17 years. What Supreme Court has said, you know it. The learned single judge has said it. You can't help. All right, tomorrow. Don't do it again. We have granted you adjournment, but don't. What we have told you as a young lawyer, always remember, your status is much higher. You are an officer of this court. Here in a dignified manner. Don't be this. This doesn't matter if you lose this case, but you should not lose the face with the court. What you should have said fairly, sir, my concession may not be recorded. The law is against me. We would have remembered you for your fairness. This is what an advocate is supposed to do. You have to be fair to the court, not all the time because he has given some instructions. So do whatever is possible to protect the interest. No, we have granted, but we are telling you. What did you try to do? Initially, you sought an adjournment. Monday, no, you said Monday. Then we said no. Then you said day after tomorrow. Then we still said you said tomorrow. Virtually begging, no, for a case doesn't look nice. Or come ready, we will pass the order if you don't appear. We are telling you clearly. Don't appear if you don't. If you are afraid of your client, don't appear. We pass an order.
34, 14%, PS Mohan, Srimati Vaishali Hegde.
How much time? Wait for a while. Wait.
35.
You have prepared a synopsis, right? Fine. Yes.
35, Sri Sarvana.
Hello, I'm appearing for the appellant, my lords. I kindly seek pass over, my lords.
What dispensation and what this thing, madam? For dispensation, you seek a pass over?
My lords, no, my lords.
On IA number 1 of 22 and 1 of, I heard on IA's number 1 of 22. For the reasons assigned in the application, requirement of production of the translated copies as well as typed copies of statement of objections is dispensed with. In the result, IAs are allowed. What is it, Mr. Ramesh?
I appear for the.
We have allowed IAs.
I take notice has to be ordered.
Notice.
At best, notice may be ordered.
My lords,
yes.
My lords, senior will be appearing in this matter. My lords.
Senior has already appeared, madam. Senior.
My lords, my senior.
Acha, we thought Mr. Ravi Verma Kumar is appearing with you.
Therefore, I kindly seek pass.
No, so these two IAs have been allowed, madam. This is, we can't hear it finally. After a long time, I must confess that on account of procedural ignorance on my part, I always heard preliminary hearing as final hearing. This is not to be done. We have to take up 2011. What is the justification of 2021 writ petition appeal being heard out of turn at the cost of the litigant who is waiting since 2011 and 12? This was a procedural lapse on my part. I am admitting it openly that I have been hearing these, which I should not have heard and should have entertained this thing. This always preliminary hearing is nothing, it's admission. If you want admission, we will admit it if you are happy with it. What password? Issue notice to respondents.
My lords, we had sought for the stay in this matter, therefore, my lords.
So there is no stay matter. It's not listed today. Please see. Get the matter listed if you want to stay.
Please, my lord. Please, my lord.
36, Sri Prakash Shetty, yes.
What? Yes.
Subha,
What memo, Mr.? What memo? Fast. Avoid confusion, not to list preliminary hearing, only admission or orders. What preliminary hearing? They start arguing. What preliminary hearing? Everything should be under admission. Ask them not to list anything under preliminary hearing. What is it?
in the year 2019. Thereafter, you have continued in 2020.
We have heard you for right? You are arguing that it's a systematic matter. What is to be done again? Then we are asking you to be heard finally. Not we can't hear this finally. We will list it for admission. What preliminary hearing? What does preliminary hearing mean? It is admission, right? No. You tell we no. We are asking you, Mister. You are an officer of this court. We are asking you what does preliminary hearing mean? Preliminary hearing means final hearing. So these are all final hearing matters, right? From whatever is the heading under preliminary hearing. What do you want to say? No. So therefore,
I am without employment for about 1 year.
No. So, Mister, you argue on admission. That we understand. If it is admitted, it will be heard. You argue on admission. Yes. All right. You are engaged as a consultant in Swachh Bharat project on contractual temporary basis. Your services have been terminated on account of unsatisfactory work and complaints against the appellant in purchase of material. You say that the termination is stigmatic, therefore it should be quashed. The single judge has held that it is in accordance with terms of your employment. That's it. What else?
Great respect. Another single judge, para 7, if you are not please. Page 19 and 20. The other judge categorically says there are several complaints against me. But with respect to
where is the order of record, yes. Last date you were asked to produce a record, madam. So you should have told us, right? We forgot about it, what transpired. So inquiry has been held.
In this case, he is only a temporary contract employee.
Fine. That means you, if he is a temporary employee, even if he is a temporary employee, you cannot say that you are a thief, therefore your services are terminated. That is not the. So therefore, so where is that order terminating his services? Page
number 130.
130.
Translation is at
151. That is the only point, madam. That's the only point. He is a contractual employee. Supposing if he is entitled to 15 days notice, you give 15 days notice, terminate, no problem. Nobody is saying.
We have done that. We have issued show cause notice on 1/7/2021.
No. Read what you have done. Read.
What is that? Discharge order is at 151. Translate. In reference to the above subject, it has been noted that Mr. Mukesh Gopani, who is working as solid liquid-based management consultant, is not discharging his duties properly at the expected level, and there are.
To hear it's all right. Thereafter the problem begins.
Yes. And also, the complaint received against him in this office, alleging that he said consultant unnecessarily participating in the purchase of equipment and materials by the Gram Panchayat under the program being implemented under the Swachh Bharat Mission Gram Panchayat scheme. It should be continuous measure. Complaints are also alleged. The translation is not very effective, but it is the one sentence measure. Complaints were received against him, whereas where the complaints were received, I have produced the files. Earlier cases was to be extended. These services were not the cause of satisfaction.
That's all. But the problem is this thing. Complaints received.
It has gone in the PMO office. But as far as the PMO office is he has
Madam, whatever it is, law remains the same. Law will, even if it goes to PMO office or anywhere else, International Court of Justice, then also the law remains the same that services of a probationer cannot be terminated by a stigmatic order. No, mere self-serving statement will do, right? You will say it's not a stigma, so we will accept it and dismiss. What is it? What is it? No, complaints. You have stated in the order. That's what, if you would have said that his performance is not satisfactory, then fine. Up to that. But you are taking into account the complaints also against him. What complaints? Naturally, how can you say that this is not stigmatic? Up to this stage, that his performance, up to this, you are well within your right to say that you are employed on a contract basis, your performance is not up to the mark, therefore we are discharging you. That is fine. But you are saying complaints received against him and you are telling it is gone to PMO. So it will change the law if it has gone to PMO office. What is it, madam? What are you trying to convey to us? If it has gone to no. So we are concerned basically with deciding. We are not concerned where it goes. We told you even if it goes to International Court of Justice or US, doesn't make any difference, right? If you think like that, our job is in this appeal is to decide whether this order is stigmatic or not. We are asking you a simple question: what is the law? You have not brought any case law, nothing. You are just standing here and saying it is not stigmatic. That's fine. This is how we don't think that this is the way to assess the court. You should have worked hard. You should have brought the case law. What circumstances it can be. Even you have not produced any case law to say that you are well within your right to say that. We are telling you that you are well within right. You are only telling us that it is gone to PMO, and you are telling us that there are complaints and we have conducted an inquiry.
Small inquiry. Complaint is about corruption. They say that
This, madam, a prima facie, in our opinion, this order is stigmatic and therefore it has to be questioned. Fine. If you want to cite any case law in support of your this is not fair, right? You should concentrate on everything. Right now, you will say that supposing if on next date of hearing we ask you something else, you will say that now I am concentrating only on case law, so I don't know anything. What this is what? Sorry. So no, madam, it says simply complaints received by him alleging that. What is the effect of an order stating that the complaints have been received against him? Why did you mention? You have not even brought the case law in saying that you are well within your right to terminate the services of a contractual employee, provided you find that his performance is not up to the mark. That research also we have to do it. Then this is what I mean. And you call yourself officers of the court, equal partners in the administration of justice. You have assured my lord that the bar will cooperate. This is the cooperation. When he was elevated, what did you tell him? What did you tell him? Bar will fully cooperate and will assist my lord in effective. So how my lord will write the judgment if you are not telling anything? Why have you not? Just in any case, the result is an adjournment. What is the use of doing this all exercise when the result is an adjournment?
But we are before the appellate court. The learned single judge given a categorical finding whether several complaint means 7 of the order. That is their contention. Now, you are are aware, Supreme Court 3 2
We are not aware. We are not aware about anything. You have to assess.
The affidavit of the party will be only open of the order, original order of the.
So, madam, you.
The Supreme Court, they cannot substitute.
She's praying for an adjournment, right, to cite the case.
Let the order may be taken, let her take a time. Otherwise, I have been out of it.
So, I mean, we will allow your appeal. We will allow. Have you come across where the order of termination passed on 26 July 21 is stayed in March 2022, merely because April 22, merely because court has said something in your favor. We are discussing, I mean, tentative about it. We have to hear you. My brother told me that we had asked her to produce the record, so we looked at it. And from there, we made a query. It's not that we have not to hear you. Not that we are allowing. Why we should? If you want, we will reject your prayer. Yes, learned counsel for the appellant. Fine. Reject. No. We can't stay. What? We can't stay, right? Learned counsel for the appellant submits and the.
I am not pressing for it. Here I dispose of any date next week. I am ready to argue the matter with citations. If you are not, I will conclude my argument.
But she is praying for adjournment. What can we do? You ask, not fourth time. Why this case should be Mr. No urgency. No. This is for preliminary hearing only. This again we are telling you. This is not for final hearing. We will admit it. Appeal is admitted. Appeal is admitted for hearing.
May make one submission. Repeated. Here and decide in the admission stage. If it is heard or not, I will know where. Therefore, I request your lordship at the time of preliminary hearing, a convenient date of your lordship, here and decide the matter.
You are telling next week who will write judgment, Mr. Next week, everything next week. Right? Whatever case is listed today, for one reason or the other, it is being already pushed to be. Last case also you saw. We are telling you as an officer of the court, don't be confined to this, your petitioner. Last case also, we had read it, we asked the counsel the question, he said tomorrow, he said Monday. Everything, who will write judgment, Mr.? We are human beings. We wish that, we wish that we had the power to recommend you for appointment as a judge of this court. You could have worked better. We are human beings. We have our own limitation. We cannot decide all the cases and deliver judgment because you want it.
I have great respect to both of your lordship, both are hard working.
No. We are.
There cannot be any dispute at all. But I have great respect to your lordship. I know that you have been doing a hard work. Several matters are disposed of by your lordship. This short period, there cannot be any dispute. But I request your lordship to please say the date, not penalty your date. I am ready.
Madam, prepare a synopsis. Date wise, prepare a synopsis. This can't be, every case can't be heard like this next week. And be ready on the next day. There's nothing. This is the only point, whether it is stigmatic or not. And we don't have to wait through the facts when he was appointed, what was done. You give a synopsis in one page. We cannot ask him. He's a senior man. You do it.
I got a synopsis for citation also.
Next week. You wanted it next week. We have done it next. Adjourned it to next week. What else?
I only assisting lordship by placing.
No. Yeah.
You can place it next week.
37.
Next week we have. You wanted it next week. We have done it. Adjourned to next week. What else?
I only you are familiar fixed date, not immediate. Otherwise, sometime office will not move. Immediate, you are familiar.
What day? Sunday is convenient to us. Will you come? 10th April.
Your lordship asked me to come at any time. I am ready. But you are not. I am also available.
No. Mr. Please understand that every day is convenient to us. We sit from 10:30 and we are here. So don't say convenient. All cases are being adjourned either at the instance of you or at the instance of respondent. She's saying what to do. That's the problem.
But ultimately, we are before you are we are
So
bound by it.
next week there are only 5 cases. 18th April. 3 days. Next week. No, 18th April. 18th April. Madam, we will decide it even if you are not ready or you don't appear. Fine?
I'm sorry, if you anything I said, I think.
No, nothing. That is your job, right? To pressurize the court to get a judgment today itself. That's what that you have done your job. What is that?
I can only try to pursue your lordship.
No, but Mr. Counsel, what we want and we want to tell you through to the members of the bar that we are also human beings. All the time we cannot be pressurized to decide every case today itself. Now, right now, how much pressure it is on our staff. Everybody, please realize this someday. And it's not that we are doing it only for today. This is our daily job. Next case, some other counsel will appear. He will say, no, it should be heard right now. This all the time we are pressurized. Please appreciate that. There's nothing beyond that. 18th April. Yes.
37, Srimati M.R. Vanaja, government educate.
So that's what you should have told us, right? Instead of inviting the decision on merits. So henceforth, please save time and please, because every minute is important. Third, Learned Counsel for the petitioner submits that the rate petition involving similar issue has already been entertained and interim order has been granted in support of the postal submission. Reliance has been placed on because of you. Other counsels were afraid that supposing if your petition is dismissed, what will happen to their case? And you were inviting a decision on merits yesterday. So they gave us this copy, told us, no, sir, several petitions are pending. Mr. Vikram Uligal, he told us yesterday, there were several petitions. They felt afraid that what will happen to our bench if this petition is dismissed. The Court of Appeals Reliance is placed order dated 20th February 2022.
Anxiously waiting. Anxiously
Waiting. WP number 3997 of 2022 in view of the submission and directed that in case petitioner deposit 10% of the amount as assessed by the authority in the order dated. What is the order? What state? Where is the then? So we will entertain this appeal. What is the no state?
They have issued direction to the bank to not to.
Issue notice. What state? So you are saying that no order of assessment. What state? No, there is no absolute stay, madam. This is 10% of they have to make a deposit. So what amount? What stay? What stay? There is no stay like this. Issue notice. Yesterday, along with WP number 20.
38, Sri Sanjay Nayak, government advocate.
Yes, yesterday you told us, right? Where is that order? Learned Counsel for the petitioner submits that the petition involving similar issue has been entertained. Interim order has been granted in support of aforesaid submission. Reliance has been placed on the order dated 2/12/2021, passed in WP number 0016/2021 in view of aforesaid submission and with the facts of the case. And with a view to maintain parity, it is directed that no coercive action shall be taken against the petitioner for recovery of the amount mentioned in demand notice annexure C till next date of hearing. It is further directed that on petitioners paying the prescribed fee for issuance of no objection certificate, the respond number 3 and 4 shall issue the conviction certificate to the petitioner, which shall be subject to result of this petition.
Number 3 for dispensation of
Or at 3 of 22, requirement of adding whatever is dispensed. Yes.
Number 39, is Dinesh, government advocate.
Yesterday your matter was supposed to. Mr. What happened? He has taken admission in BDS course and thereafter participated in the mop-up round. He participated. When was the mop-up round hit? After taking admission in BDS course, he is entitled, right, to participate. Medical. So he was eligible to appear. The only deficiency is that he is otherwise meritorious, right? That's why he has been allotted a seat. No, not this MBBS, mop-up round. Not allowed. So then why?
But they did not allow me to produce the document in half an hour. I was able to get the documents.
No, but he was not allowed to participate in mop-up round. Huh? Mop-up round. Yeah, just a minute. We are just trying to understand. We'll hear you. Don't worry. Yes. Why we hear it? Because he has a pro-student approach. So if there is any solution, he himself will tell us. So we are just trying to understand. Correct. All right. So what did you do? 21st March. Following documents are required to be.
All original documents they said in verification stage. And you have to bring and submit it because other the last form of paper there will be skip law. You have there also you have here also. Until you do whatever brings it, takes a week, then you will be put to that. That will not happen. And this law for us was given. The national agency you have to start with the either the 17 lakh rank. State. It's on 20 lakh. Page number 7. Block letter.
29th March.
29th March. From 9 to 11, 9, 15 to 20. 15 to 20. There, many of them don't have one. But the next one will be waiting here. It's offline. The last day. But it's not big. The effect is not wrong.
These documents were verified in the earlier round.
It
was verified by you earlier. And the originals were submitted earlier to you. Whatever it is.
Oh.
The remaining seats is also not vacancies have been where I thought for petition cannot get this
Yes.
The documents are verified by the authority may not on 28 February 22.
Where mop-up round has been held on 29th March. Where is it? That is BDS. That is BDS. That is BDS. Please understand. Fine.
And the reports were there, they were verified.
No, they are not saying that. I mean that your admission to BDS course is illegal. Nobody is saying. We are on 29th March. The question is, what is the effect of non-production of documents on 29th March?
29th March, I requested for time. I rushed to the college and got it within half an hour. But they did not allow me. And at the end of the evening, they surrendered all the things to the management.
So if anything, you are going to have hold any this thing straight. No further round.
You are not making any grant me new days that you have. They have to create a free infrastructure.
All right. Mark the presence.
Play round is also over.
Mr. N.K. Ramesh, Learned Counsel for Respondent number 3. In this repetition, we heard. In this repetition, the petitioner has sought a writ of mandamus directing respondent number 1 to allot MBBS seat in any of the medical colleges by verifying the documents of the petitioner of 10th and 12th standard paragraph. When the paragraph, Learned Counsel for the Karnataka Examination Authority submitted that the petitioner was admitted in BDS course. Thereafter, the petitioner became eligible to participate in the mop-up round. The authority notified the procedure for mop-up round by on 21st March 2022. Full stop. The aforesaid notification clearly provided that a candidate is required to carry the documents at the time of original documents at the time of mop-up round. Full stop. However, the petitioner did not produce the mop-up round, did not produce the original documents on mop-up round on 29th March 2022. It is further submitted that mop-up round is over and no further round of counseling shall be held by the Karnataka Examination Authority. Full stop. Paragraph. At this stage, Learned Counsel for the petitioner prays for adjournment in order to enable him to place to cite a decision of the Supreme Court. When do you want? Monday? Just on 13th April, 11th April 20.
Admission number 40, CH Gupta, TG Ravi.
Admission. We will admit it, Mr. Appeal is admitted for your record. Maintenance we will hear. All right. We will pass it over. Please wait. Then other counsel is not there. We will pass it over. No, we will take it up today itself. Yeah, we would have decided it just now, but the council is not there. Then supposing if we pass an order, just please understand, if we pass an order today, just now, on your prayer, he will file an application for recall and say that the order has been passed in violation of principles of right and justice. That's the problem.
I will get.
Your experience should tell you how difficult the job of a judge is, right? Huh? Yes. That's all right. No, we are not saying that we are adjourning the case. It is being passed over only for the counsel for respondent is not there. We are not saying that we don't want to decide your application. There is nothing in not deciding. What is there to decide? We have to ask what is he doing, what is his salary, and that at that basis we have to determine. So there is nothing great about it.
41, the Rudrabhushan CP.
Ask for right 40. 40%. Appeal is admitted for hearing record.
Party two
Is admitted for hearing record. Interim order shall continue.
program unit, the
My lord, serial number here for respondent, my lord.
Any people to oppose you, online, offline mode, from every district. Like, for
we have got right
for innovation of what hotel.
renovation and running lot of equipment and not up to that we have to do. That lot continuously lot valid even today. And on the number of 14 years, even the change in the management of they say why it is a term and not coming. We challenge it, we not fight section money. That was not granted anymore. He came over the your lordship not passed the final order saying that definitely in my favor, till not the entire arbitration is over. And I will consider
Where is that?
that
$75.
Respondent is distinct from every component taking possession. If not, the arbitration proceeding for some. Then, but consent, what am I going to my consent, but arbitrator appointed is not just arbitrator is already go. All appointed as might be arbitrator. They are not smart to but we find out that next is saying that the domination is high. But get what you know. They also find that counter saying that I was handed over possession to them. Then I get about after the entire evidence was over after trial.
examining party, examining about all the documents, evidence, come to the conclusion that what I continue not till the concession period is over 30 years. And what intention was granted in notice. They filed a complaint the right of side was possession to them. Then what they filed a section 34 application for the commercial. Commercial court was actually overruled the order in section 9. They put up the order did not have need to read the same and not say I am now making setting a section. But more important, they will not file a counterclaim on for 2 days in the section 34. But can I declare the certificate being continued to the
Page 35.
35 days. It's 82, but I not probably enough. Get from the job, I mean, I shut up. You get it. You get 121. Responded to the creative group, limited by the province section of law 32B and 32B of the convention. Claiming to enter the award of community group, claiming responded from visible society or from intelligence and legal people in the schedule on the basis of the reported termination notice. Event that this is challenge on the section 34. Please come to that take that. I'm not going to come to a 36. There are 2 prayers for $5. This is not my last part, but 36. This is an arbitration. My last page at the bottom. Yes. The arbitration of the late 1996 in the to set aside the award date is also asked by the second respondent in arbitration case number 77 of me. And now the pattern of the means. To deliver project property to the plaintiff without any encumbrances. Now the Lord cannot come here except please come to Lord not pay. What is the paragraph? 82. If you have 42 is asking for in the result petition is allowed. To the extent prayer and a problem not with cost, only not prayer 1, not prayer 2. Prayer 1 is set aside the award, prayer 2 not is to put them in. That is rejection. That was 3 years time. I wrote about the they want without taking any policy what they do is they will not deal with some police. Police and put their off.
What is the period of lease of
For a period of 30 years. My work they just come to the concession agreement in volume 1. You were paid 90.
Till the date.
For a period of 30 years commencing from 27th of September 2003. So 30 years will be 33. What they do is very significant. They come and not imply the reason. They come and block the reason. Not imply the role. Agent's photograph, we do not the lot. I am not the date also is there. After not there. Just look at what you this also Supreme Court. This nothing about that is Vita sitting there as a judge is on a court. I can appeal to be on the NG road, Mahatma Road. There is utility building, belongs to the party. There is cinema hall. It also belongs to the party. They will not have these in favor of on party. That is why. Then what they came up with the process of punishment. I have not tried to force the this all report what you can't do that. He comes to what running the 166. That what there cannot be a forcible eviction in India. Paragraph 9, it says what clearly takes up for the facts. And paragraph 9 is your something.
This is based on 68 Supreme Court 320.
Can I request you to just look at two of judgment of the Honorable Supreme Court itself? Please come to what running page 77, 1989, 2 years in fee. 5.5. There is not is not the negative word basis. As we tell you all before the Supreme Court as a PD judge. Seeks of legal pedigree required to please look at paragraph 13. But it starts at page 177. Not it means like adding goes to look at.
No. Yes.
Dealer not sitting there not really times.
No. Yes, para 30.
180. Letter with the death time has no right to receive position extrajudicially for use of force. Even after the expired early termination use of the does not authorize extrajudicial measures to receive position. Under law, possession of the living, even after the expiry of the early termination and go to the disposition. The letter cannot be dispersed, otherwise none is due process. In the present, the fact that the letter is the same does not place it in any higher. It is under the medicine stemming from the requirement that all actions of the government and government authorities have a legal pedigree. The Bishop Draft was the state of Punjab. It is like this court said. But they have what ultimately what the Honorable Supreme Court granted. Even a trespasser, I not again moralized. Sometimes we are impudent to bring all these different sure impudent. But can I persuade about it? Just turn to page 199. 2010, 8 years in 68. 199. Paragraph 46 of this judgment. My not get that not at running page. 202. Paragraph 46 both is. 214. Start at 199 and 214. Cannot be totally, cannot be evicted. I don't know what some Supreme Court for all those different picture are.
60.
Absolutely. Yes. Then not the I heard commercial code. What will not overrule for section 9? And what is it? I know that I take for judgment for my work country. They can't be PMC. Later judgment of Supreme Court in 2022. Please come to not page 156. With regard to not the scope of section 34, 156. The latest judgment, but please come to not paragraph. Correct that. Do not page 156 is given, RHN will not be that page 158. Taken in several cases, do not is that the court does not take it over and above passed by an arbitrator, and the only ground on which it can be challenged are those which have been specified in section 30 and 30. When there is a element of case to award, and when the learned arbitrator misconduct the issue for the proceeding, in this context, in the usually refer to quality manufacturing corporation versus central scale housing corporation, where it is observed as follows. The outlet. You know, the scope of the report with regard to arbitrary award is limited, both considering and application does not contain both the findings and principles are nor can it reassess or reappreciate the evidence or examine the sufficiency or otherwise. Ultimate number of judgments are kept for. What has happened is, even not annual possession. In fact, the master paper book was already such for. They were some disability because not one of even earlier, when the matter came up and section 9 was rejected, they weren't walking. Injunction was granted. They will not speak of because we are inside, but position has not been taken. We are putting a law outside. That does not follow from laws. They take the law. Police does not do the government organization. Therefore, not they come and come with the police. But the bigotry, even though not the word.
Okay. Yes. Yes.
Whereas license, it comes to the section 54. Railways, airport, bus stand, everybody, we give the license. Government of any government of factory, we give the license. The particular stop to run. We can't go for filing a suit for emission. So that scenario will not happen in a license cases. Because all the judgments are pertaining to the landlord and tenant are enforced. Here, we are bound by the contract. Before they approach the man, there are continuous violations of the conditions of contract and the agreement. For which we were forced to issue a notice. What?
Yeah, hearing would be on stay, it's not being heard finally. Whatever prayer for. So what we trying to tell you, we have not decided we finally or whatever it is on interlocutory application. Yes.
I am assisting the court regarding the misrepresentation, fraud, perpetuated in the institute as this are court.
All.
And as for this, I do case of the meeting before, fraud initiates all activities, all actions of the court also. If there is a fraud is detected.
All right, so we have got the notes.
Yes. In 2003, the appellate was granted a conditional agreement. That's what exhibit C1, this is marked. Continuous violations are there. Paragraph number 1. JK 14 in notice of violations and breach of conditions of agreement was there. Well, issued by respondent number 1. It 60 days time to correct the violations. Then 11/12/2014, preliminary notice for termination of license for violation of conditions was issued by respondent number 1. Third, final notice that the termination notice was issued from the violation of conditions of agreement. Exhibit C1 was issued by the respondent. The party. Now we look at the party. Page number 50. Connector R1. My lord is got it.
Who is some concession agreement 48.
Yes. The concession agreement was on 27 September 2003.
Page 52 is definition and interpretation, article 1.
I'm sorry, I beg to submit this one. Sorry, there might be pages.
Page.
First page with the calculate.
So it's 48. 48. 48.
Yes. The parties are ASTDC as one part as a concessionaire and Hotel Maithana a proprietary service concessionaire. In other words, it is a licensor and licensee. There is no word in the entire agreement as landlord and lessee.
You told us a relationship between the parties is of the licensor and licensee, not a lease under section 105 of TP Act.
Yes.
It is a concession agreement.
Yes.
Violation of the agreement is
Yes.
done. Therefore, termination notice sent. Then
Sure.
dispute arose.
Right.
Whatever happened.
Hotel Maithana.
Huh?
But party here is licensee is the Hotel Maithana. One XYZ relative of a proprietor of C party Hotel Maithana. It also mentioned here, represented by last page of that document may please be seen. The signatory of this document agreement is one Vishwanath Shetty with the proprietor of Hotel Maithana. number 50. Now in present page number 79. Because there are many conditions are there not to violate. In the case of violation, we will issue termination notices and we terminate. After termination, now question is who can approach the district court under section 9 as a party? Now we look into the section 2H of the arbitration. Party somebody approaches. There is very safe. We cannot do that.
Where is the finding by the?
Yes, there is a finding.
It can't approach. What is it?
Yes, that finding is also there. Everything is there.
Can you tell us that?
Now we look at the section 2H. Party means a party to an arbitration agreement. Means Kotu Maitana represented by Vishwanath Shetty should have approached. This under section 9. And here under section 9 has been filed by one Karnataka Shetty, not Vishwanath Shetty. Of Anjar Associates. He files arbitration application under section 9.
What Shetty you said? Kana?
Karnataka Shetty.
Taranath.
Shetty. Not the party as per section 2H of the arbitration. So there specifically under section 9 clearly stated. Interim measures. So right. One. A party may before or during the arbitration proceeding, or that is not necessary. A party. The party is referred to definition of 2H. So what is expected under law is Mr. Vishwanath Shetty of should have approached. It is good. On the contrary, he has taken the back seat and somebody other than Vishwanath Shetty has approached to section 9. And final application. Application came to me. Idea came to me. Section 9 is the main application. One idea under section 9 also filed that idea can be rejected. Rejection of the idea is MFA. The Karnataka Shetty approach. Is affidavit. Who is no longer concerned by a party.
What happened? MFA order was passed.
It's a misrepresentation and fraud. I'm submitting. The fraud, because justice and fraud cannot dwell together. As per the judgment which has been referred by my lord, there is a senior friend. Senior sir, Meghamala case. The justice and the fraud cannot dwell together. Well, without knowing the fraud has been committed. 3740 was entered, but no interim order was
3740. What?
3740 of 2.750.
Where is it? MFA. Which MFA, Mr.
MFA 3740.
Which page? I don't remember the number of MFA.
Yes.
We are not parties. So which page of what?
In today they have submitted. Page number 340.
340.
We look at the 340, the lordship. May I request to look into the page 231. 231.
What is document? Volume 2.
Volume 2.
341.
231.
31.
This is not affidavit. Affidavit was filed by Mr. Karnataka Shetty. who is no longer to a party to the agreement. He declared a misrepresentation, a fraud, and abuse the process of the district court. And the main petition is 221. Petition, this is the supporting of it, I am showing. Third part. First one, Amendment was filed by Karnataka 233 में please this. Karnataka, son of Karnataka, residing from Karnataka Mandal Village. As you have read, our agreement is nothing to do with the Adhikar Associates. Karnataka Mandal Village now at Bangalore on a visit to Bangalore 2 years back only. This main petition by Karnataka Shetty, idea was also filed by Karnataka Shetty. This is the matter. Rejection of the IA has entailed for filing a 3740. Once again, the Karnataka Shetty. It is admitted by 321 with the word of property.
Is contention urged by you before the earlier bench, which had disposed of the MFS?
Yes.
Was this contention urged?
No.
Why are you raising it here now?
No,
you were appeared in that. Why did you not raise these contentions before the earlier court?
No, the Apex Court, that's what I have submitted. Apex Court said that even confusion by the lawyers.
You yourself had appeared in that case.
Will not approve or endorse that illegality. Once said before the court, we have to say before the court that what we have submitted before the learned decision under section 34. A 3740 was filed. No order can be passed.
Where is it, Mr.? You are referring. We don't know what is 3740. We don't know. Please tell us. We don't remember cases by number. Huh? 240.
In the head note itself.
What happened to this?
The court
There's no order.
Court passed it matrix proprietary partner Karnataka Shetty, who is not a signatory for our agreement. The MSA was filed by Karnataka Shetty. Intentionally or cleverly, or by oversight, they have not produced the affidavit of MFA. MFA affidavit also was filed by Karnataka Shetty.
Fine. Now we have understood. Not very difficult to understand that application affidavit in support of application under section 9 as well as appeal was filed by a person who is not a party to the arbitration agreement. Fine.
Yes.
Go ahead, Mr. We are only deciding in
Yes.
interlocutory application. Yes, please. So what else? Then it is all vitiated by fraud.
After even 7172 of 2017 was.
What is?
This was pleased to pass that you complete the section 9 application which is pending before the decision.
Where is the order?
That order is there. 301.
30. Yeah. 1 is the not an order in 3740. You said MFA. What happened to this MFA?
This area to be dismissed. Under section 9, arbitration application can be dismissed.
No, you said MFA 3740. What happened to this MFA? When? Where is the order?
So they have passed. So they have passed. I am looking the pages.
All right. So MFA dismissed. 262. Page 262.
Sir, AA came to be dismissed. Arbitration application of section 9 finally came to be dismissed by the order dated 22nd August 2020. Here's the order. And evidently, page number 349. 49. It is from Mayor of GS, Dr. Mayor Bill Shahi, Ambedkar Society, to MD KSBC. It is what is dated from. Then the single judge was pleased to pass an interim order, not to disturb them. And by attaching that particular order copy, he files this application. That's point number one. Then once again by the third one. Okay. These are 40 can be filed. 7172 can be filed. 7172 up to 70 can be filed. This was the by the Indian bench of this, one bench of this, starting from page number 358. It was read by a senior.
You appeared in this case. Your name is written by Shri Gururaj Joshi, advocate for respondent. Yes.
Already an arbitrator has been appointed. You please go and raise all your claims and counterclaims, whatever may be. Claims, defense, and counterclaim, whatever may be, you go to arbitrate. Now, the technical skill. When the AA itself was filed by a third party who is not a party under section 2H, whether MFA could be considered as legal or it should be treated as honest. Number one. If MFA becomes honest, two MFAs filed by third party, not a party to the agreement. If two MFA become honest, appointment of arbitrator based upon this MFA becomes honest. Arbitrate. File in a written argument stage. There is no relation between the case EDC with the semi-government organization and the Karnataka of Punjab. Correspondences and petitions filed by undergraduates Karnataka has to be shut down, to be neglected. This has been filed before the in a written argument. If you are not framed pertaining to that particular point, but under Article 14, if you would have been framed before filing, no issue came to this framed. they are touching, I am touching from this side. To assess this on report regarding the there is no prima facie case because to consider the application of 39(1) and 2 as reminded by my lordship, we are only concerned at this stage, not for the final hearing, but the prima facie case, whether there is a prima facie case in favor of the appellant. To find this application of 39(1) and 2. So there is no prima facie case. Now, in this background, please look into the second volume. Second volume, starting from class examination. He admits, all one he admits, there is no connection with pharmaceutical.
Page number.
Page number 9. 9. Second volume, page number 9. Just now,
Cross examination where?
Before the advocate. Still the deans, he admitted that he had no connection with Ganja, he had no connection with pharmaceutical as far as legally reasons.
Who had issued this termination notice?
Termination notice was issued by he was
Termination notice is issued by you.
by us.
Yes, and you have issued it to Tarnath Shetty.
There are 3 termination notices. I will commit. There are 3 termination notices.
Go to page 284, exhibit R21. Yes, this is issued by you.
Issued by me, addressing to proprietor. Also yet. Because it is as per the agreement.
Who is representing Anjar Associates?
Anjar Associates is appointed by Power City, whereas party to the agreement is proprietor. Proprietor from my country.
Why this termination was notice was issued to this second address also?
This termination notice created this. Created this.
What is this?
This is the directing into handover.
Directing the handover is not termination.
Yes, sir. Earlier termination was issued, it has been seconded to the learned arbiter. Now that the arbiter in the award, learned arbiter was pleased to second all the termination notices.
8.
This is a termination. This is also very important. Now becomes sound also.
Take 56 months. Here, incidentally, our advocate, then our advocate, now he has become a present justice. And their advocate has become a present justice.
young people stand a chance. I think you have crossed the age, right? Okay. Yes.
I crossed the age.
So these young people will stand a chance. That's what we are saying. The young advocate accompanying you and other these two persons. Yes.
I bless everybody.
Yes. So, Richard, what's C3?
Yes, C3, page 56. That the first notice is came to be issued for the violation. From Justice Emmanuel, to the proprietor, for the Maikana, also Tamil City partner in the assistance.
So you are
page about one development meeting. I need to bring it. One page clear to that. Page 55 I page this. Page 55. Why this all this juggling is happening? Page 55. They have sought for converting the proprietorship form into the partnership form. They have sought for, the voting party has sought for permission for letting out 3 shops and also letting out some portion of our project property for IUC. These are the 3 permissions they sought, and which we have granted. We agree. Exhibit C2, page 55. Page 55. With reference to the above matter was placed before the board and they have agreed. The board for the result to grant the permission for letting out the 3 shops in the and in this one and for permission against partners firm as well. From this point, they are not found any partnership firm, but we presume independently we presume that you have found the partnership firm and the current setting is the partner. Based upon this letter, there is an appointment order is there. He has not appeared, he has not joined the duties, but the firm is that he is fine. Like that. Further, please also refer to this one with regard to the payment. Now, in this background, we look at it. And also, please look into the concession agreement where the attachments are there. Page 47 of the second volume. Page 47. Page 47. Notices to whom we have issued. Pertaining to starting from page 46, notices have to be issued. If it is to be issued, the case is also addressed, and if it is to be considered the proprietor, Hotel Maikana, SD Temple Road, Rampur, Gulbarga. But whereas the property is in Bidar. Next, all such addresses, telex number or personal number, as may be duly notified by the respective parties from time to time, shall be deemed to have been made or done. Shall be deemed to have for the delivery purpose. Technically, I am replying to the question raised by my lordship. That one you have put the also at Karnataka. Now we come back to the page 56. Then the first notice. Page 56. Then the first notice C3. Under the instruction of my client, KSTDC, I am saying the following notice to you in regard to later. You have entered the concession agreement. I skip first 2 paragraphs. Third paragraph. Third paragraph. After first C to B, you are prohibited from parting with the whole or any part of the project or facility. And as per clause 3C, you shall not without the prior approval of my client to use the project asset facility for any purpose other than for the purpose of project and purpose incidental or ancillary thereto. Upon verification of use, now exceed that particular paragraph A, 4A, on western side of the property, a function has been erected. These are the violations which have been listed in the first notice. Prior to termination, on western side of the property, a function has been erected by using the asbestos sheet and the same is part of the in favor of one Muhammad Latif who is returning renting the same to the conduct the marriage function. It's violation of clause 3. On the portion of the project asset using facing the Woodville Road, 6 shops have been built and they are also let out. And there is a shop by name Sai Shop, which is also run by third party. Building on the eastern side of the property, though being used for the lodging, the same is parted in favor of one student, Sudhakar Bhavati, and you are collecting the rent from him. On the building, on northeastern side of the property, though a hotel is run, again the same is parted in favor of one Babura or Sinanga, and he paid you the rents. On the backside of the project asset, though a bar and restaurant is run, the same is again parted in favor of the Dr. Jaldi, and you are collecting the rents from him. They are the clear violation of clause 3 A, B, C. So above are violation under 3B and 3C. There is a first one. My lord, you please look into the page for 59. Who is replying? We are addressing to for Maithana. The additional address, but reply is given not by the party to the agreement. Reply is given by Karnataka City. Page 59, my lord has got it. Is the C4. Is right into the case. Every case. But everybody all in gaps. Whatever has been done is done under the law. Next, it's 62. Criminal notice came.
All is fine. Ultimately, it brings down to only one submission.
Yes.
That the order is void and therefore the appointment of arbitrator is void, award is void.
Yes.
That's all.
Yes,
Whatever documents, all these documents.
There was a submission made by the senior counsel that section 30 was very limited. I also agree it is very limited. But whenever the main question remains is
where is it set aside on the ground of fraud? Where it is set aside by the commercial court?
Arbitrator is appointed on the basis of a joint memo filed by you.
Yes, that's what I have submitted my worship. That even though there is a concession on a disputation, that cannot justify and endorse as per the Supreme Court judgment of the latest Supreme Court judgment that any concession it is against the agreement or this is against the law. Cannot bind parties. Cannot bind. Even if I give a concession today, if it is against the agreement, if it is against the interest of my party, against the law, cannot bind my party at the end of it.
Consent given by you for appointment of an arbitrator, can it be called as a concession?
Because the reason is clause 9 of the agreement. Clause 9 says 3 arbitrators have to be appointed. One by case, one by the party, and third arbitrator by the 2 arbitrators. Third arbitrator by the 2 arbitrators. That was the clause says. So we cannot go against the agreement clause.
You have understood his argument. All fraud. Yes, we have got your submission that it's all fraud and it's not binding. Award is void, rightly set aside by the commercial court. Yes. That's the submission.
Yes.
What else?
No, read that. Once it is set aside. Once it is set aside. We come back to the stage of the termination. Means termination order notices and termination letter communications which have been set aside by the arbitrator have been set aside by the arbitrator. Once that happens, so that nullifies the arbitrator award. Once that alternative award is nullified, what remains is we are coming back to the stage of termination. When we come back to the stage of termination, what we have to look into? What are our rights?
You can take possession. Under the
agreement. Agreement says so. If not, suppose if I am a lesser.
No, agreement doesn't say that his employees are inside you, you lock it out.
No,
That's what it is. So you can take possession, right?
I'm coming to that point. That word I have yesterday I have said the misrepresentation and incorrect submission. Why I am saying incorrect submission is that? Look back. Then I will explain our rights. Then we
are only deciding an idea, mister. Not rights and all this. Supposing if we, whatever you are arguing, if we accept or reject it, what will happen? Then you will rush to Delhi. They are only. Yes. So they are not entitled to injunction because they are not in possession, you are in possession.
Not only that.
You have taken possession on 28/3.
28, no.
When have you taken possession? Where is it? Possession taken on 26/3. All right.
2022.
How? I mean, you went there and took possession.
Not only that, the employees have signed, and including Karnataka also signed. Who was there? Because Vishwa Shetty was not there. He said, I am representing Vishwa Shetty. He also signed. Here is a copy from the president. We have today.
Where is? Where is? Which page?
That's an R9. And translation copy is there. Next page.
It's not signed by Vishwanath Shetty, right?
Not signed by
So this is also fraud. Same whatever document is signed by Taranath Shetty.
See the employees. They will see. Translation copy is R10.
Which page?
Page number 10. R10, the 94. But we are in the hands of the We are in the hands of the Here in Bangalore, whatever the documents are produced before me. And I am having video. Particular point of yes.
Objection, page 10 is something like this.
Okay. No, my lord.
You said page 10.
94.
94.
Yes, sir. That's in
34.
94.
Yes. There are some photographs. You have.
Monish Gowda.
94 is like this. These are the photographs.
Yes,
94 is the copy. 94 is the copy of the Maza which you just found that you are signed by Karnataka.
94. Not there.
It is in 93.
90. 90. Panchanama is 90.
Yes.
Yes.
Then our team went there to take position. Mohsin Gowda, son of Mohandas Gowda, 20 years cashier at Hotel Mayo. Number 2, Iqbal, son of Mainuddin, 36 years waiter, Hotel Mayo. Suresh Pujari, Amit Pujari, manager, Hotel Mayo. all these three persons, in presence of the officer, they have signed. And the photographs have been taken. Including the person who was all along signing on behalf of the voter by Karnataka, Mr. Karnataka also. Now, let us say, for argument's sake, if there is a confinement is there, our 25% confinement is there, as a that will be reflected in the IA, which was filed along with the appeal. So, legal question, in the common sense, not particularly according to common sense. If to 2016 we have taken this panorama, we are logged into premises, in all the login photographs have been produced. And appeal on 28.3, they are not whispered anything that, not a single word that our 25 people are there inside, they have been confined, which is violating our punishment 341 of the IPC. It is not there. So it is after. Now we look back to the what you have stated. You have not whispered Mr. Vishwanath Shetty, who has signed on oath the affidavit supporting the IA1, has not whispered anything that our people are there, one person is there. There are two options, my lordship. One is giving a police complaint, or giving a private complaint, or submitting the habeas corpus. That our persons are being locked up in the place, they should be produced before the court. Number 4, that should have been reflected with the names and addresses and the age, whatever what they are doing inside. It is affidavit. Now we look at the affidavit. Why since yesterday I was submitting this matter is that there is a different minds are advising them for a wrongdoing, misinterpretation. That. I request please look at the affidavit of the IA1. Fine, Daddy.
We are looking into everything. That's why so many flags, right? This is also see. We are looking at everything.
I should not any aspect.
No, we are only deciding again. Again, we are telling you we are only deciding IA.
Yes,
if you want.
Oh, that way only.
I mean, so long, 45 minutes. Yes, fine. What is it?
I'm too small. I'm too small.
No question of
because if for IA for injection, senior people is coming. I'm too small for them.
No. Please go ahead.
Please. Affidavit. He doesn't say anything regarding the first page of the second page of the affidavit. He doesn't say anything. Third page of the affidavit, he says regarding 8/8/2014, the termination notice, whatever happened. Fourth page, he doesn't say anything. What has happened there? Fifth page, 26/3/2022, paragraph number 12. The response number 1 came near the scheduled premises along with the pose of policemen and locked the main gate, even though our employees were inside the hotel and continued to be inside the hotel premises. Latest photographs of the gate which clearly indicate the lock put on the main gate and the employees who are inside the property would clearly indicate that they had acted in the most high-handed manner. I state that we are running a restaurant, so whatever they are running, I further state that around 50 people are employed who work in the scheduled premises with daily livelihood depends upon. So illegal closure of the scheduled premises would affect the livelihood of the people working there in the premises. I said that we have made investment. Investment is there. Heavy investment was made from 2013, 300. I said that paragraph 16 regarding the Supreme Court judgment. The affidavit Supreme Court judgment was being quoted. I am advised to believe this. The paragraph 17, interaction of the respondent number 1 is wholly illegal. We apprehend that the respondent may forcibly take the position of the scheduled premises. Here at one side, on 23 we are taking a position. And another side, paragraph 27, they say there is an apprehension of taking a forcible position. Under these circumstances, we are constrained to oppose this report. The balance is to be in favor. And is most respectfully declared that this honorable may kindly grant an order of injection restraining the appointment from entering upon and taking position and control of the country. We want the relief. Now, we look into the specifically that section 39 and 38. Regarding the 39 regarding the 93. Here, looking to our photographs and the consumer, no names have been produced by the where photographs we have produced, front gate, back gate, all doors, everything is been closed. Let us presume, because they have sought 25 lakhs as a gain for comparison against us before the learning application. Then in that context, let us presume it is there in the paper which has been submitted by the person. Now, when there is a loss can be quantified according to them. If you are already clear with you on the learning application. Even if we loss will continue and our position will continue till the final decision of this appeal, can be quantified as a compensation. That's where the second leg of the three legs of the injection procedure. One is there is no frame of reference. Second is irreparable loss is not on them because it is quantified. Well, already we have 45 lakhs where without any evidence, the learned administrator passed the order for 1 year. Then also second. Now, this balance of evidence is a selling of the property which has been now has to be seen, my lord. The photographs are there. We have given them a project to run the hotel, not for running a forum mall. Not for running a forum mall. Page 85 of my statement of objection with PGC Annex R2. Earlier photographs. In my statement of objection, page number 85. What is rating has been given? Innovate, maintain, operating cost. Where I got it? Annex R2, page number 85. And photograph. Yes. The next photograph may please be along with the complete compound wall. Illegally, they are erected 12 shops. Next page. Five gardens, Element Gardens, that's one, Shivaji Club Road, Ratnaganga Hotel. This designated the entire front portion of our hotel building is city government. Public property. It's not my property. It is public property. It belongs to the KSTDC. I have evidence. I have this report. You ask me why you are on all these steps to consist on this. Agreed. Further, Proceedings and Palace. Next, spot gift, Dhamaka offer, all these things. This is a prior to our termination. Therefore, we have terminated and we come back to the termination. Based upon our termination, we are returning the position. And now, I come back to this lordship. The right of termination. The same statement of this, starting from page number 53 onwards, this agreement. Now, look at that. For 70. Page number 70. Termination of this agreement for any reason whatsoever. Any reason whatsoever depicts and interprets that whether our reasons are right or wrong. Upon termination whatsoever, the case study shall upon making the termination statement, if any, the constitutioner have the power and the authority to enter upon and take position and control of the project and project facility forthwith. Forthwith. Private constitutioner or any person clearly proved or under the constitution from entering upon and dealing with the project facilities. Notwithstanding anything contained in this agreement, case study shall not, as the constitution of termination otherwise have any obligation whatsoever, including but not limited to the obligation as to the compensation for the loss of employment or continuance of the regulation of the employment, absorption or re-employment of any ground. We are not means encumbrance are not limited to us. We don't along with the party. So now, when we come back, we have taken on 23 and no action under the police IPC provisions are maybe purpose have been filed before the police or the magistrate court or before the Honorable High Court of Karnataka. Claiming for the relief of them. And no names have been known. Their contention is illegal. Now, what is to be done? Mandatory injection. Mandatory injection and distribution. It's not applicable. It is to generate within 6 months. Not to the license license. Then I can quote about hundreds of judgments. I'm not trouble.
Thank you. Thank you. Thank you.
I'm not trouble.
Thank you so much.
Because I have 180 years of all judgments right from Moose Court, King's Court.
But we don't think it is required for deciding temporary injunction. You have put it with so much of clarity. I mean that no prima facie case, no balance of convenience, no irreparable injury, nothing. No, he has relied on only 2 decisions.
The list of decisions are there. And with copies. With copies.
Please cite. You are free. Please cite. You also cite. We are bound to hear.
This situation of the man. What do I have to do?
Where are the notes?
Today I have notes. What is the conditions? Number 1, 2, 3, and 6. Number 4 we already read. Segment of the commercial code. Typical question resumed on 23 is concern about product of division. I can take it right or we should correct. In prima facie, there is no case. Now, hence, on 2, 23, 2, 3, 2, 22, so appellant had lost the physical question. It's saying who are the project property. Then it is released only mandatory injection. Not as found in the IO1. And 5 people, 28 to 3 to 22. 5 people from IO1 and 2. That is the second point that the appellant cannot claim restraining order on the project property once he is not in possession of the property and when he has no prima facie case, he will not sustain legal loss and balance of money. There are 4 judgments are there. starting from page number 3, paragraph number 7 and 12, please be seen.
Which paragraph?
Paragraph number 7 at page number 5. Elementary, it is elementary that the grant of election during the presidency. The decision whether, number 8, the decision whether or not to grant the included injection has to be taken at a time when the exercise of the legal right afforded by 2020, its alleged violation or both confiscated remain uncertain till they are established or evidence at the time. The relief by way of interrogatory injection is granted to mitigate the high risk of injustice to the plaintiff during the period before which that uncertainty could be resolved. The object of the interrogatory injection is to protect the plaintiff against the injury by the action of the uncertainty were resolved in his favor at the time. The need for such protection has, however, to be weighed against the corresponding need of the defendant to protect against the injury resulting from this having been created from exercising his own legal rights for which he would not be adequately compensated. Come to the page number 7, in page number 7, paragraph number 12. The question is whether if the respondent has violated the conditions stipulated in the agreement by changing the structure of the firm without taking the prior permission of the appellant. Here is the case what has happened. Still, the latter was bound to give it to the farmer an opportunity for rectifying the defect. In 8 2015, according we have given the 60 days notice for rectifying the defect. Whether the passing of the order revoking the agreement without affording an opportunity will render the revocation order invalid or not to be decided, considered when the suit is taken up for the hearing. These are not the matters to be considered in detail for considering the plan of interlocutory order. Regarding the question of status quo on the date of the order of injection, there was a serious dispute whether the appellant has taken over the position of the property after the notice of revocation of the agreement and served as the manager of the respondent and had made over position of the suit property to the respondent too for the purpose of running the federal bond. Here is a similar case. So these are to be looked into. Now, next judgment of the Supreme Court, 2009, page number 8, paragraph number 4. Having heard the parties and after going through the info of the order and the materials of the court, we are unable to sustain a part of the order called by the High Court. It is imposed before us. It appears from the record that the civil region case being has been admitted to the High Court of the appellant will file a case in the High Court and at the time of admission, the learned counsel for the appellant submitted that the appellant being the decree holder has already taken the position of the property through court. Here, there is no necessity for the court because it is not a, as per the agreement, we can forthwith we can take. Learned judgment in interim order directed that the appellant shall put the judgment letter in possession of the property in restitution. Since the decree holder appellant has taken the position of the property in question in execution of the decree at this date, the question of redelivering the position to the judgment letter cannot arise at all. This can be done only when the final order is passed by the High Court in the pending. That is the position the informed order to the extent that the decree holder shall be putting the judgment letter in the possession of the property until it set aside. What has been ordered by the Honorable High Court of that particular High Court has been set aside by the Apex Court. Now the next judgment, page number 18 to 20. In page number the report between the developer and the landlord. There is the purpose of the hearing. The senior counsel for the appellant developer made an offer to deposit in 10 crores this court on a without basis. The respondent, however, rejected the same offer. Since both the issues raised are seriously disputed, which will be decided during the course of the trial, we have believed that the order related to so constituted region of the High Court do not warrant any influence, wherein the High Court has already granted the temporary injunction restraining the respondent from eliminating or creating the third party rights. At the most, what this honorable court, my submission is that what at the most what this can be done is that once we have terminated, Since the legality of the termination is before this one court, there should not be any right for the third parties to not be created by the AFCDC. That can be solved. Now, case number 50. Ambalan Tarabai case, starting from Yara number 19 to 1923. Number 19, case number 19. In matter concerning to the grant of injection, apart from the existence of prima facie balance and injury, the conduct of the party seeking equitable relief of injection is also very essential to be considered as observed by the internet. I will not repeat. Delay and running and delay. Now, we directly come back to the page 21, paragraph 23, by referring to all the judgments and the last judgments. This is very important. The underlimited prescribes the rule of prudence only. Much will depend upon the facts of the case. It fell for consideration again in Gujarat Batli case. Paragraph number 47 of that case. Under Order 39 of the CPC, jurisdiction of the court to interfere in an order of injunctive or temporary injunction is purely equitable, and therefore the court on the approach will, apart from the other consideration, also look at the conduct of the party involved in the jurisdiction of this court. I pause here for a moment. The conduct of the party, which we have explained earlier, that everything has been done by the Dharma Chetty without the consensus by the party to the agreement. The conduct of the party has to be looked into further, and they refuse to interfere unless the conduct was free from blame. My lord, the second set of the, which has been submitted by the person, will show the cross-examination, everything is economics. I don't have any connection to Dharma Chetty. I have not given any assignment. He is not my partner to the Roberto Megana. I have not asked him to appear before the High Court on my behalf. It's not blame. Now, since the relief is wholly equitable in nature, the party who the jurisdiction of the court has to show that he himself was not at fault and that he himself was not responsible for bringing about the state of his complaint of, and that he was not unfair and inequitable in his dealings with the party as in whom he was seeking his relief. My lord, not only against me, against the district court, a third person is filing a application. A third person is filing before this court in 3740 and 770. It is a fairness. It is not an abuse of process. Take a mother which has been referred by the other side. Paragraph 28 to 43 please. 28 to 42. Fraud and discrimination. Paragraph 28. Page 28. It is second proportion of law that where the applicant gets an order by making misrepresentation by playing fraud upon the competent authority. Order by playing fraud the court. It has been produced by the fraud avoids all judicial acts, material or temporal. The case has been referred, and in Nazareth estate case, the court observed without equivocation that no judgment of a court, no order of the minister can be allowed to stand if it has been obtained by fraud. This giant memo has been referred in logic. You want to find by us, ordered by this other court. If it is filed by me, appeal is filed by the third person, who is not a party. Will not be allowed to continue. So there is a fraud. Further, Andhra Pradesh EPMC government, paragraph 29, 1992, Rishit Dhawan, Shah case, fraud and collusion. We can even the most thorough proceedings in each civilized system of this kind of paragraph 50. Paragraph 50. Let me hand out under fraud and collusion. We feel even the most thorough proceedings in any civilized system of jurisprudence in the concept of irrespective of human conduct. In India, legal says, 2000, this court observed that fraud and justice never dwell together. This was the first statement I have submitted before this. Fraud and justice never dwell together. They are apart. The rationale of this court in various judgments, dishonesty should not be permitted to bear the fruit and benefit to the person who played fraud or made misrepresentation. In such circumstances, the court should not perpetuate the fraud. If with all these judgments and available before the Honorable Court, if all the evidence available before the Honorable Court, in volume number 1 and 2, we submitted. I also brought it for submission. No, luckily for me, the other side is submitted. Everything is before this court. Then the continuous fraud and misrepresentation is there. If it is allowed to be allowed, continued, amounts to enhancement of the fraud and misrepresentation. Then what the apex court says? Further they say, should not permit to the court all the judgments. Fraud in the intrinsic collateral act and fraud of an egregious nature would be the most solemn proceedings of the court of justice. Right? Even not only between the case DC and the voter by color, all the proceedings before the district judge as well as before the Supreme Court, we share the proceedings. Where do we stand? But I am asked to assist this court as a adjudicatory court. I say so that all these proceedings, even the recorded bench, was this late. The Karnataka advocates who has appeared for the appellants in those cases, that the person who is signing the affidavit for the MFA, Mr. Pakapir, is not a person who is authorized under the agreement.
All this you have argued. We are on the case law, Mr.
Yes, sir.
All this you have argued.
The reference. I thought I had permitted. I thought, sorry.
So you want a final?
I am not here to disturb. I thought I had permitted to.
No, we are hearing it for such a long time. We should very well decide the appeal itself. What is there now left? You are since thread there.
No, there is no sense of
Yes.
Fraud is an act of deliberate deception with a design to secure something which is otherwise not due.
These propositions, nobody disputes, right? Fraud vitiates everything. I mean, yes. Nobody is disputing. He also cannot dispute. This also binds under Article 141. That's nobody.
The context of the party.
Fine. That we have understood.
Has to be looked into.
Unfair.
Conduct of the party. Now the another important point. It's a legal point. Legal point.
We are all.
Application under 59(1) whether it is permissible before the application. Which court says in the Hindu Consulting Company case, in 2019, it said, which is reported in 2020, I have produced it for the purpose of this one. There are 49 methods. There are 49 which starts. Page 49, page 55, in 55, in page. Application for the learned arbitrator was under section 30. Now it's the continuation of this appeal is continuation of the section 34 order. Now what the apex court says, this court has repeatedly held that an application in 34 of the arbitration is a summary proceeding, not
We are not getting page. Where page 55?
Page 55. Most of arguments. The last judgment.
You have given all wrong pagination.
All somewhere. It's not there in what you are reading.
My pagination and my lord's pagination don't tally here.
Which paragraph you are reading?
There's one more thing.
Yes. So there are, it is page 55 has been.
Yes.
So you have marked 2 pages as 55. That is why the confusion.
Sorry. Further, this court has repeatedly held that an application under section 34 of the Arbitration Act is a summary procedure, not in the nature of regular procedure. Third case has been referred to the apex court. As a result, the court reviewing the arbitral award under section 34 does not take an appeal for the award. So, section Article 39 to 1 and 2, it has been filed in year 1 of 2022. And in the other it's a protest. But it is also not been. What is the separate copy? The photocopy of the agreement of the monorail. My humble position. The final concern that the fraudulent party, there is a photo my comment after that. All along they have continued to fraudulent act against the fraudulent property, against the interest of the consumer agreement, against the interest of the public interest. For which they are intended for the condition. And now the condition has been ratified. It will be enough. Okay, we are taking. One question, what is the belief? Whether you are at 31 and 2, can a mandatory injection can be granted for the restitution of the property? My answer, my suggestion is no, it cannot. Only in the event of the final decision of the appeal. Everything is ratified by the final report. All along it is held that we endorse everything, whatever is illegally ordered in your favor. Forgo. Contempt. The restitution is funny.
Where is the contempt? Whose contempt? What? Where is the contempt? What for?
The filing of a false.
There is no contempt proceeding. We are deciding a commercial appeal and that too temporary injunction.
Filing
at this stage.
Falsely. False affidavit filing before the Honorable High Court.
This is your submission. We have to decide, right? This is your submission.
I'm assisting before the Honorable.
Yes, we are hearing you patiently.
So in this view of the matter, the IA1 and IA2. IA2 is only for stay of the once any stay is been granted regarding IA2 from the equal judgment, they will relegate back to, it relegates back to arbitration award. That is the execution of the arbitration award. So that arbitration is warranted in this case. The understanding is that it is not warranted. At the most, this matter can be heard very early, any given time. As appropriate for this one.
Yes. Only 2 minutes. 2 minutes. Yes. 55 of. This thing. Today you have been.
One or two?
Volume 2.
The letter is my PhD. Board number 3 board further resolved. The grant closing is for letting out 3,000 conflict and for formation of new partnership firm and sought for. Subject to that, Lord, Secretary was also in that. And they issue notice to my lord. The firm represented by Tara.
What is in page 56?
55.
56. Next page.
Is it is sent to my lord Anjara, Tara City, Anjara. That's why I said, they recognize this. They only gave it. Ask me, but I know, I'm sorry. Para 12 was read by my military not of that affidavit of honors. We have not indicated that the people are inside. And what we have not stated that also. Para 12 was read of the affidavit. Then we have kept page. Page not the earlier not 134.
Oh, yes. Oh, yes, 131. Oh, yes.
Specifically said, here are the photograph. Our people are inside. They are not the they were not the police complaint also. It's not that. Police came there. We not the police complaint. Nothing but after all, police came with similar to all these officials. These everyone. All are inside. Only one answer. None of these contentions were raised. The joint memo was filed by the parties themselves for appointment of the arbitration. And none of the contentions which are raised was raised either for the trial court in the section 9 or before the Supreme Court when the section 9 was challenged and injunction was granted by the law, nor before the arbitration. That's what I get.
Thank you.
Yeah.
Number 43, you get Murthy there, the answer.
My lord, I appear for respondent in this case,
Ah,
my
so
lord.
you are in the wrong case, right? Initially.
I apologize for the same, my lord.
Ah, yes. So what is it, Mr.? What has been done?
Copy is not served upon me, my lord. And I intend to file the objection upon the stay application, my lord.
This has been allowed, right? So, we'll admit, appeal is admitted for hearing. Let a copy of IA-1 of 2022 be supplied to learned counsel for respondent. During the course of the day, she praise for is granted. How much time, madam? 2 weeks time to enable her to file the objections. In the meanwhile, it is the operation in effect of the impugned judgment insofar as it pertains to dissolution of marriage shall remain state.
Obliged.
What happened? Decree, marriage has been dissolved. Appellant is admitted for hearing, copy is admitted for hearing heard on IA so and so. Issue notice on merit IA so and so. Record in the meanwhile, it is directed that operation of the impugned judgment and decree so far as it pertains to dissolution of marriage. Judgment and decree shall remain state. Insofar as it pertains to dissolution of marriage.
45. Of the KPID Act. A provisional order of attachment is made absolute by the special court. Challenge to that under section 16 of the Act.
So what?
Properties in question, members. There are 22 properties in question. If properties in question were attached.
How have you taken loan from somebody? Why it is attached?
No, why it is attached is under the KPID Act, certain investments or deposits done into the name of the company, not returned back. To safeguard their interests, my lords, initially there is a provisional attachment under section 3 by the government, my lords. Then the competent authority under section 5 would file an application before the special court. Special court, upon considering the application, giving us an opportunity, would make the attachment absolute. Along with that, my lords,
Yes, you are appearing in this matter.
not take notice, but I have been to lots of notice. That's not one property.
Ah.
In fact, Lord, this is part of that. I don't want to use the word scam, but quite a huge deposit of.
He has gifted properties to.
69,000 depositors. Over 2,600 crores is the claim made by the deposit. 2,600 crores.
And how many deposits?
69,000 deposits.
How far have you collected?
We have lots. No, these are the properties which have been attached. 12 crores we have been able to disburse. 12 crores.
12 crores.
And now that these properties are assessed at about 350 crores. Therefore, we will not be in a position to satisfy all, but the commissioner has a scheme. The least of the minimum deposits are first satisfied, and then with proportionate pro rata we want to go. That scheme also I want to place.
Yes.
We tried for IRS.
Ah, yes.
This is a public interest litigation got filed.
Yes.
It's something what
She told us. Ah.
And inquiry by the Central Bureau of Investigation is on. And this what was in fact was monitored by the court insofar as the attachment to the process is concerned. We have reached a stage where attachment has been made absolute. And we are now in the process of disbursing to the
Yes, you file objections to this IA. Thereafter we'll consider, but it's a statutory right.
I understand.
Issue notice on behalf of respondents is accepted by learned Advocate General with so and so additional government advocate. She accepts notice on behalf of respondent. How much time you want to file objection? Yes, for it is granted 4 weeks time.
What they have done is without waiting for the statutory period to be over.
Yes.
Either yes, but ultimately money of the deposit. Either yes, deposited money. Or not, we must because a huge queue of deposits in front of our office. So the question of public interest. So he does not have a possession of the property. Sorry, this pertains to attachment of properties. The idea of this attachment is, my lords, it is attached even under PMLA, my lords. Now, after the entire trial is over, if it is liable for confiscation.
The idea is so that you don't disappear with assets. So just hit and run away. The idea is that attachment. Nothing is being done, right?
Attachment has no problem.
Nothing is what is being done. Just one.
Then we present the scheme for a lot of properties we want. We could possibly dispose of and not.
Yes.
Or not lots of permit us to do this. Subject to what permit us to dispose of the property. The money we will keep in the account. So that that will at least facilitate deposits. But ultimately, you say that dominant public interest. And all these persons, small little investors, 5,000, 10,000, 25,000, they are 1 lakh. We will dispose of what we in a position to sell this properties and keep that money in the account. We will not disperse the amount so that we secure.
You file objections, then we will consider. You do it within a week or so, right?
Yes.
You take it up on 18th or something.
Yes.
So let them 18.
One request would I make, my lords. One request. Now the 30 days statutory period for us to file the appeal, my lords. Now before the statutory period, yesterday 13 crores from a bank account they dispersed, even without waiting for the statutory period to be over. My apprehension is, my lords, if now they sell the properties and
it can't be sold in a week, Mister. What do you think? What do you think of property?
Say that, my lords, after 20th.
Yes.
Up to 20th.
Yes. Praise for short accommodation to enable him to fight objections to IA 1 of 2022. List on 20th April 2022. He said, no?
Yes. 24 miscellaneous file against which one we have to file 24 MFAs. We have filed 1 MFA now. The remaining 23 is also going to come up in the same way. It will all have to be
it is not before us, right?
Yes,
What can we do?
Yes,
he will appear on 20th also.
Yes.
He is being driven by public interest, you know. Yes. Okay. Yes. Yes.
We have the Central Act and the State Act. We are attached under both. Under PML Act, attachment, central government is chosen. Under KPID Act, state
I
government.
find we have had enough, Mr. On an application for temporary injunction. We have been detained for 1.5 hours. So please spare us today. Enough. It's being adjourned. Thank you. Thank you. Which password? What? All password. 14%. We should be more than 14%. Another part had matter. FC case. Huh? FC.
Which is the family court.
Family court. Call.
Maintenance, the old man. Old man's maintenance.
Oh. Yes. What is the maintenance? How much you are claiming? No, that's fine. What is your husband doing? Husband, what is the respondent doing? What is his income? Mr. Shetty, this is an application. He on his request, it has been just a minute. On his request, we have taken up the matter. There is an application for maintenance. So the only criteria, what is the respondent doing? What is his income? How many dependents? That's the 3 questions. We will pass an order. Please tell him what is the respondent doing? What's his income? And how many dependents? That's all. Income of
They are getting about 25,000 rent only this one house.
Where have you said?
And
Yes.
as a contractor business, every farm life and houses.
Was there any order by the family court granting maintenance?
Was any maintenance granted before the family court?
Where has he said what is the income?
About 55,000. Income is more than 2 lakhs per month.
Where have you said what is the proof? Income tax return filed.
I have only said you will not take what you know it in paragraph 10. In paragraph 10 of my application, what you know it, I only have said.
Sir, marriage. Ten holds one. What is the income, Mr.? Instead of 70,000.
More than 2 years, she has no knowledge of the income of the husband. Except that she was kept in very well position in a good furnished house.
So you are saying that rental income of 70,000. What else? Which other income? Which other? Who is dependent? Who are the dependents on the respondent? How many parents? Sir, whether any children has, any child is born? No children. And your in-laws are there? In-laws. In-laws, in-laws. Ask the lady. Ask your client to come. She is there, right? What? We have.
Para 17 of the.
We have seen that. So she will tell. Ask what whether in-laws are there.
Yes. ನಿಮ್ಮ ಅತ್ತೆ ಮಾವ ಇದ್ದಾರಾ? ಇಲ್ಲಿದ್ದಾರೆ. ನಿಮ್ಮ ಗಂಡನ ಜೊತೆ ಇರೋದು ಅವರು? ಅವ್ರ ಜೊತೆನೇ ಇರೋದು. They are there and they are staying there.
If rented income is 70, then
proof for that rented income. I'll put there an application. Application number. Yes, yes. ಏನ್ ಕೆಲಸ ಮಾಡೋದು ನಿಮ್ ಗಂಡ? ಏನ್ ಬಿಸ್ನೆಸ್? ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಬಿಸ್ನೆಸ್. ಅವ್ರಿಗೆ ಮನೆ ಇದೆಯಾ? ಸ್ವಂತ ಮನೆ? ಬಾಡಿಗೆ ಬರ್ತದ? ಎಷ್ಟು ಬಾಡಿಗೆ ಬರ್ತದೆ? ಇಲ್ಲಿಗೆ 70,000 ಬಾಡಿಗೆ ಬರ್ತದೆ. ಎಷ್ಟು ಮನೆ ಇದೆ? 4 ಫ್ಲೋರ್ ಇದೆ. ಅವ್ರ ಅಲ್ಲೇ ಇರೋದಾ ಬಾಡಿಗೆಗೆ? ಇವ್ರು ಅದೇ ಮನೆಯಲ್ಲಿ ಇದ್ದಾರಾ? ಅಲ್ಲಲ್ಲ, ನಿಮ್ ಗಂಡ ಅಲ್ಲೇ ಇದ್ದಾರೆ. ನೀವ್ ಯಾರ ಜೊತೆ ಇದ್ದೀರಿ? ನಿಮ್ಮ ಅಪ್ಪ ಅಮ್ಮನ ಜೊತೆ ಇದ್ದೀರಿ. ಏನ್ ಮಾಡೋದು ಅವರು? ವ್ಯವಸಾಯ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. He says this income is 70,000 rental income. Real estate, you don't know.
No.
15,000.
All right, we'll pass an order. Thank you. What is which case, Mr.
40.
30.
No, this is 40.
40. Yes. Mr. So and so, Mr. A.S. Gupta, learned counsel for the applicant. None had appeared on behalf of the respondent on 31st March 2022 also, and none for respondent has appeared even today when the matter is called in second round. Learned counsel for the applicant submitted that the applicant is. All right, we are passing in order awarding maintenance. Learned counsel for the applicant submitted that the learned counsel for the applicant, while inviting the attention of this court to paragraph 13 of the affidavit, submitted that the respondent has a rental income of ₹70,000. It is further submitted that in-laws of the appellant are residing with her husband. Full stop. In view of full stop, we have considered the submission made by learned counsel for the respondent. None has appeared on behalf of the neither anyone has appeared on behalf of the respondent, nor any objections have been filed to the prayer for grant of interim maintenance. Full stop. Taking into account the averment made in the application, which is duly supported by an affidavit, as well as the fact that the respondent is deriving a rental income of ₹70,000 70,000 it is directed that the respondent shall pay a sum of rupees 25,000, 20,000 by way of maintenance to the applicant from the date of the application. Accordingly, IA number 1 of 2020 is litigation expense also will have the sum of rupees 20,000. In addition, the respondent shall also award a sum of rupees, shall also pay a sum of rupees 60,000 by way of litigation expenses to the applicant. Then accordingly, IA number 1 of 2020 is disposed of. Then say in the beginning appeal is admitted for your record. IA is disposed of. Also fair as you have seen what has happened.
Only 3 minutes.
No.
Only 3 hours.
It's 47, your lordship will take after lunch.
Obviously, we sit till
Yes.
1:30. It's 10 minutes past.
Yes, that's the time.
Half an hour. We have heard you more than 45 minutes on last date only.
I finished up as a this I have done.
Ah.
Just I will pass on only numbers and
Yes.
then I will go.
Just 15 minutes.
In this case,
15 minutes his lordship says. You come here, you are unable to see his lordship. Ah, yes. Can you see?
yes.
Ah.
Let's submit.
Yes.
Only 2001 recovery certificate was issued. Again on 4/6/2002, another recovery certificate. And 21/7/2003, because I have produced on 1st or 4th, first of April, sign-ups given that we
Whether they are all relevant for the purpose of considering this state appeal.
all the recovery certificates have been upheld by the High Court and also Supreme Court. And in all the recovery certificate, the High Court says that there is a clear violation of Section 25O for that for related party. They just act it for they are not being they are on continuity of service. That is the High Court argument. I would like to 11/2/2011. After all recovery certificate has been upheld by the division bench and also the Supreme Court, the Deputy Commissioner has issued directions to the Tahsildar to recover the amount under the Karnataka Land Revenue Act. With a much difficulty, all the workers came to Bangalore by Jata, by walk, and submitted memorandum that in spite of it is the 2001 matter. For the last 20 years, the workers are starving and 50% of the workers have died. And more than 50% they are all aged and starving. And they are given direction to Deputy Commissioner to recover that amount, and Deputy Commissioner has attached the property of the entire sugar factory for the sale. Then they went to BFR. They said that even though Supreme Court has given directions, they say that the BFR says that it is restricted. You cannot recover the amount because it is restricted.
This order in WP number 303 of 2015 that has attained finality. Order passed in WP number 303 of 2015 that has reached finality.
That has been finality. But in that one, the entire amount has already been paid.
Now the learned single judge has set aside the order of the labor court only on the ground that the order passed by the labor court is beyond the directions given in WP number 303 of 2015. That's the only ground.
That is the only ground.
You have to concentrate only on that. Why it is bad?
And my humble prayer is, before that, this honorable court has directed the management give a finding to give a finding 2012 matter. Other than kindly see the just I will read the. We have to be finding 2002.
Read para 14 of the order passed by the single judge. Para 13 onwards. Please read para 13 onwards. And you. Yes, para 13. And you say why this observation is bad. Yes. 13 of these learned single judge order. You have to submit as to why this observation is bad. That's the only thing. 13 and 14, please read.
This matter of the present case is written into the order passed in 1955 and annexed 8 entrance 4 level 17 terms of
1903 up to 2015, dated 6/7/2015. My humble submission before that, this honorable court has directed the tribunal to give a findings on whether there is a 25O violation or not. That was not at all considered by the tribunal. The page number 181 on 28/6/2012.
You are in appeal as against the order passed by the single judge.
Yes.
Single judge has set aside the order of the labor court only on that ground that the orders passed by the labor commissioner is beyond the direction given in the earlier writ petition. Yes, why you say that? Yes, you submit only to that extent. Why it is not beyond?
This was not implemented. That's all my humble prayer. Paragraph 24 my kindly receive, Your Honor. Page number 207.
207.
207. Matter is referred to the industrial tribunal. In my view, the question of giving effect to the recovery certificate does not arise. The orders of the deputy labor commissioner, which is produced clearly proceed on the premises.
202, that is not an order passed in WP number 303 of 2015. You are referring to some other order.
I am just this will kindly be seen, Your Honor. This is also order. Before passing this order, this order was passed in 2020. There is a direction. This direction was not implemented, and the tribunal has passed after this order. After 2 years, they have passed this order.
Yes.
Violating this order. This will kindly be seen. Para 24.
Yes, we have seen.
The settlement which is arrived between the management and the union is reached by section 25 of the Industrial Dispute Act, in as much as clear permission of the closure was not obtained. Incidentally, all these questions are raised by the industrial tribunal. The parties therein are required to take a decision at the hands of the industrial tribunal, and thereafter, if a finding is recorded that the settlement between the management as well as the workers' union is not conformity with the section 25 of the Industrial Dispute Act, then the recovery certificate can be implemented. I am of the view that in the given set of circumstances, the question of how to the recovery certificate does not arise. But however, if it is kept in abeyance, still the proceedings are concluded in the this one. And para debate 209 last paragraph. The industrial tribunal can expedite the dispute.
Yes.
This is the order passed on 2012, and this order was not implemented. There is a clear violation of this order. Instead of implementing this order, after 2 years, they have passed the tribunal has passed an order. After 2 years, the tribunal orders may kindly be seen. Again, yes.
If you have any grievance that the labor court has not passed the order in compliance of any earlier writ petitions, you should have challenged the order. You have not filed the writ petition. Writ petition is filed only by the other side.
Other side?
Yes.
And the directions was given by the High Court. And all our recovery certificates, they have sent it to the tribunal to give a finding. All these five recovery
You are arguing something beyond the scope of this appeal.
No, my humble submission, Your Honor, this final recovery certificate has been referred to the industrial tribunal.
Yes.
To give a findings. But that was not given. What about my file recovery certificate, Your Honor? It has already been upheld. And the BFR also they have dismissed, stating that the factory was purchased for only 0.4 5 crores, but it was sold to the 300 crores. And the BFR came to know that they said that 300 crores loan they have taken. Then the BFR said, how you have taken loan for 300?
That is not the subject matter here.
Yes, sir.
That is not the subject matter here.
My humble
Don't argue all those things which are not subject matter here.
Para 16, page number 277.
I've been asking you why this order passed by the learned single judge is wrong. You are not submitting that. Other than that, you are making all other. Yes, you have to submit why it is wrong. You have to submit as to why it is wrong.
Why it is wrong means my humble submission is when there is already directions from the Honorable Court. Your findings for 25 and all my recovery certificate in spite of the Supreme Court decision.
Yes, yes, you have that you have already submitted. We have heard it. Next submission. Yes.
And my submission is even though that the orders were there, the page number 277.
Yes.
Para 16.
Yes.
The government has referred the present point of dispute under the reference regarding the illegal memorandum of settlement dated 2/4/2008. And the management has to prove that the settlement is not illegal. Further, as per the requisition number so dated 28/6/2001, it is held that parties therein are required to take a decision at the ends of the industrial tribunal. And therefore, if the finding is recorded that settlement between the management as well as the union is not concerned with the section of 25 of the Act, then the recovery certificate can be implemented and also held that the tribunals are expedite the dispute. The party realized the above findings and Honorable High Court cannot be expressed by me since it is not available. They said that the High Court judgment is not available to tribunal. However, it is clarified that the second party that these all points of reference are kept open for adjudication between the parties and that which is only the government has made the reference for adjudication. Therefore, reliance on these findings, the main dispute carried over upon the Honorable Court of Karnataka has no such significance now, since the government has made the reference for adjudication of the parts of dispute as directed by the Honorable High Court in the administrative petition. The first party has also questioned whether the settlement could be arrived at violation of section 25 of the idea, and it is no more distinct it as it touches the merits of the dispute, and there is no application for the limited purpose of adjudication under section 584. The first party has no reference, many citations of the points related that is not concerned. The first party has enclosed the copy of the appeal filed in the so that is also not. In 21, the second party again reiterated that the reference came to the pursuant to the order dated 2012 of the Honorable High Court, and in the petition number 44349 of 2016 and 14. Those orders have become final, and as the reference is made by the government to the court, the tribunal will naturally be bound by the statement. And consequently, these rights present before taking the tribunal consideration. The issue relating to the closure is not even remotely concerned with the points of this court referred for the adjudication. And these allegations contents that will not survive for any consideration. The tribunal agrees to the above submission of all reserved citations and for copy, but it is only clear that in view of criminal business required to declare the validity of settlement, nothing is related to the closure. In obedience of the orders of the Honorable High Court dated 28/6/2021, the second party also submitted that in any event the management did not upon the class and did not close the industrial. For any consideration or
I have seen that, not in a single case, everything there. We have to start judicial. We have to call them and find them.
Yes.
The directions of this honorable court was completely violated, and they have gone for IS-16 after 2 years.
Yes, we have.
And they have gone for,
Yes.
It has gone to, my lord,
Yes.
restriction 303. In 303 restriction orders, there is no violation.
Yes.
In 303 restriction, it is clearly said that the entire amount has already been recovered. The amount which has been paid to the workmen, 5 crores and odd, has already been recovered, and for balance amount, they have issued the recovery certificate.
Yes,
for
yes.
11 crores and odd.
Yes.
That was brought to the notice. And the Honorable High Court has directed the tribunal to consider that one. And after deducting after considering this one, and you may pass order like that. The requisition 303 in the categories.
Yes. Your case is that the directions issued in the earlier writ petitions have not been complied with.
That has not been complied.
Yes. Yes.
And this clearly amounts to contempt of court.
Yes, we will hear the other side.
And this 303, my lord, another day, what it says.
Yes.
Here it says para 16 appendix.
Para 16.
Para 16 of page 291.
Yes.
In course of rejoinder, Mr. Mohan submits that dispute arise from the statutory violation. He submits that the amount disbursed under this agreement in question are substantially recovered, and the certificate for the recovery of the balance amount has already been issued. This is the 16th. And para 24.
Yes. You go to para 26 operative work.
24.
24 is only the submission. Go to 26 operative portion. That is your submission, Mr. That's not the order. Go to 26.
26. The challenge of orders one number 2. 1 month time is given to the petitioner and 379 workmen to deposit the amount which they have received under this agreement in question. If those amounts or any portion thereof are already recovered from them, they shall produce the supporting documents and the tribunal shall give the direction for the same. It is made clear at the risk of repetition that only those portions of an amount which have remained unrecovered are required to be deposited. This is the order. I have submitted that the entire amount has been recovered. And the entire amount recovered and the balance amount has been paid. And here my submission, Your Honor, this is a closure fact. It is not a voluntary retirement. They have relied on, the management has relied on the voluntary retirement. Single persons who has taken voluntary retirement, he gave an application to the management that I want to go outside. And the man says that Bravery has given an application to the management that you want to voluntary retirement, I will go. He takes entire amount and he will go and again he file a case. In that case, they say that you will refund the amount and then prosecute the case. Here in this case, it is not a voluntary retirement. It is a closure. Closure means it is a mandatory provision under the section 25 of subsection 6. If the closure is illegal, then management is bound to pay
This court had directed the petitioner at 379 workmen to deposit the amount.
Yes.
Has that been done?
That has already been recovered.
Yes. Yes. Then we will hear him. Then we will hear him. Then we will hear him if it is already there.
Another submission.
Yes.
What is another thing is, if the petitioner of those 379 recording claims also as directed before them, they shall be decided to prosecute the case.
Yes. The question is only whether they have deposited it or not.
Yes. The amount to be deposited shall be kept in a fixed deposit for a period of 4 months. If some workers deposit and if some
other workers do not deposit, the labor court shall take up the reference for a coroner's for inquiry and adjudication while dropping the cases later for non-compliance.
Yes.
Here in this case, out of 567 workmen,
Yes.
the recovery certificate was issued for 567 workmen. I have produced the division bench order, wherein it clearly says it has already been marked as a R1.
Yes.
And it has clearly says that the 567 workers wages are to be paid.
Yes.
And that is 2002. Page number, one of the page is the page number.
What is that?
That is the division bench order. We pick up in number 2185 or 2006. Dated 31st July 2007. Annexed R3. Wherein the judgment para 1 it clearly says the dues of 567 workmen has to be paid. The commissioner has issued recovery certificate 4/6/2002 by law. And 4/6/2006 they did not dispute that the workmen are only 336. Here it is 567. Out of 567, 397 have taken the settlement under protest. I am also one of the employees. I have also not taken the settlement amount. Along with me, my secretary has also not taken the amount. And another 150, only 88 workmen, they did not taken the amount. What is their fate? So far they have not taken. 2001, a recovery certificate was issued on 2001. And so far, for 181 months, single person was not. And the management argument is our workers are only 377 workers. It is not the 567.
That is not the dispute here, mister. That is not the dispute here. We have been telling you repeatedly that is not the dispute here. In spite of that, you are repeatedly saying that. That is not the scope of the appeal.
My humble submission, my lord, that what the single judge order, we kindly be seen that that was not at all. They have not seen these documents which are produced. The document was not examined by the single judge, and it has passed. These are marked. The court has directed the first party workmen to produce the documents. What is the demand you are raising? That may kindly be, it may kindly be seen. My lord, I have produced it in the page number 277. My list of documents. What is the one? One court. Page number 6. Number 5688 was 2018. Parts of this one was for it was judgment produced by the appellants. That is first I have produced those documents in the office and have obtained the autonomy.
Yes.
That is
yes.
There clearly says this honorable court says Sri C.S. Mohan has appeared in person pursuant to the order passed by this court by directing the petitioner counsel to take out the notice on him. Having heard the learned counsel for the petitioner and for the respondent appearing in person, this court is of the considered opinion that it will be necessary for the certain as to what was the nature of dispute raised by the respondent number 1. before the appropriate government, which resulted in an order of being classified under section 10(1)B of the Industrial Dispute Act 1947, dated 2001, Annex 3. The said dispute which was raised by the respondent would show the right of the issue involved in the litigation. Hence, both parties are directed to place on record the said petition representation submitted by the union, which terminated the order of reference dated 5/5/2011. The then Conundrum submitted that further proceedings in ID 155 or 2011 pending before the U.S. Tribunal Bangalore shall not be proceeded till the next date of hearing, and at this juncture, listeners who are appealing for the respondent number 1 or 2 is submitted that he would not proceed with the matter before the U.S. Tribunal till the next date.
Oh, why are you reading that?
That one.
Why are you reading that?
Huh?
Why are you reading that? How is it relevant?
This is the direction which given. Accordingly to this direction, I produced the document.
Yes.
That the dispute raised
Yes.
by the union.
Yes.
That is regarding illegal closure.
Yes.
That was not at all recommended by the government.
Yes. Yes.
And it was then I also produced the High Court order.
Yes.
And I also produced the government notification.
Yes.
That government notification was not at all considered by the single judge.
Yes.
After serving this, not free of restriction,
Yes.
decided for 300 to prosecute the case.
Yes.
The government has passed another order.
Yes.
Amending the reference.
Yes.
That was not at all taken into consideration. That was not at all seen by the honorable court.
Yes. Have you filed your written statement of objections?
I have filed.
Statement of objections were filed. Yes.
My statement of objection is that page number.
All these documents are part of that.
All the documents.
Yes.
Yes.
Yes, we will consider it. If it is a part of that, we will consider it.
My first submission, Your Honor, this most important.
Yes.
Page number 325.
Yes.
Of my objection statement. There is a government reference.
Yes.
After passing the 303 restriction,
Yes.
the government says that it is not a voluntary retirement, it is a closure, and whether closure is illegal or not, this is the, my lord, you can see the page number 325.
Yes.
The industrial dispute between the workmen and the management of the system regarding illegal settlement dated 2/4/2018, which was to declare illegal void and no effect. This is the demand of the union regarding closure application. And the government has passed an order. Right, you see the government order is at page number 341. The points of this good. With reference to the problem, you got it at page number 341. With reference to the point, with reference to the previous government order, now stolen dated 5/5/2001, point of dispute refer copy after the second dispute, so 3 and 4 additional points of dispute. Whether the president should be the employee union of the employee union means very below and EHS affairs in the employee union establish that the management of the group of chemicals very below has closed the factory from 18 to 2002. Although violating 67 or obtaining without obtaining the permission from the government as per section 25 of the Industrial Dispute Act 1947. Establish what relief the employees are entitled. This is the government order. For this government order, the management has obtained the interim stay. I have produced it at the stay order is. I produced it in my list of judgment, my lord.
Sir Mohan, this court had repeatedly asked you, we are putting you on notice. This court has repeatedly asked you to read para 13 and 14 of the order passed by the single judge and make your submission as to why that order is wrong. You have not said that. And you have been, and you have been wasting the court time by reading all irrelevant materials. We are putting you once again on notice.
My humble submission is.
Yes, you can continue, we'll hear you. But we are once again putting you on notice. You have been wasting the court time. Yes, you can argue.
This is most important.
Yes.
Your Honor may see that this important.
No, we have asked you a question. You are not answering the court question.
That order was not at all.
We have asked you the question at the very beginning itself. How this order is wrong. You read para 13 and 14 of the single judge and make submission as to how this order is wrong. Instead of doing that, you have been reading all irrelevant things.
These two orders were not considered by the single judge. That's why that order has become wrong. Suppose if this stay order is brought to the notice of the single judge, he would not have enforced that order. They have suppressed this fact. This fact material was not brought to the notice of the single judge. That's why he has passed the wrong order. It is very clear that there is a stay. When there is a stay, they cannot proceed the case. That is the law.
Yes.
That is the Supreme Court decision.
Yes.
If they have considered these two cases, my lord, they would not have enforced that order. One is the government reference, they have amended the government reference regarding violation of 25 and regarding 567 words. And that government order was not considered by the single judge. They are not seen at all. And the management has obtained this order on 8/4/2018, 8/4/2018, 8/4/2018, single judge order has been suppressed. It should have been brought to the notice of the court that there is a stay order. And they have said that it have been brought to the notice of the court that the government has issued a reference. Reference is not that one that which has already been said that it is not a violation, it is a closure. And that the important fact has not been noticed by the honorable court. And that's why that order was and my humble submission, even otherwise also, that order was passed by the single judge without considering my statement of objection. In the last para, you may kindly see the order. It has made it very clear that there is no need to see the statement of objection and documents filed by the first party workmen they are stated. My humble submission, that is most important. And they also, there is a clear violation that 25 is the direction from the High Court. That was not at all considered by the single judge. That's why I submit that it is the wrong order.
You have said that don't repeat the submissions.
3 times you have told.
Don't repeat the submissions.
Yes, sir.
Yes.
My humble submission is 25 violation. There is a direction on 2008, which I have already been marked. That was not been considered. That was not considered that even though they have not given the findings on 25, the single judge has passed the order. If it was considered that the order passed by the single judge, the tribunal regarding that issue, there would have been that order would not have been. That was not considered by the statement.
Yes, thank you.
My humble submission, my lords, the poor workers since from 2001, my lord, have been suffering. My humble prayer is the recovery certificate which has already been upheld. The kindly directed the deputy commissioner to recover that amount because it has already been upheld by the division bench and all the authorities has not been satisfied. And there is a clear issue, my lord, the Supreme Court judgment. This will kindly be seen, Your Honor. This is very important. This is worthwhile judgment on another day. I have got to kind notice, my lord. This is worthwhile judgment reported in.
Half an hour is over, right? You told half an hour. Half an hour is over. What is this?
Only two judgment
I conclude within 5 minutes, not beyond this. No. This is not, we are hearing you on admission only, whether it's a fit case for admission. That is the scope. How will you, this thing? Please go ahead. whatever you.
Your Honor, my kindly see the page number 52 of my list of judgment. If that is AR Supreme Court 1555. The document within the meaning of section 2P, read with section 3 of section 18 of the Act, undoubtedly binds on the workman. But the question which would arise is, would it mean that thereby the provision contained in subsection L and section 25 was not required to comply with? The answer to the said question must be referred to in detail. A settlement can be arrived at between the employer and the workman in case of an industrial dispute. An industrial dispute may arise at regard to the settlement, at regard to the validity of the agreement or the closure or otherwise. Such a settlement, however, as regards the recruitment or the closure, can be arrived at provided the recruitment or the closure has been effected in accordance with law. The requirement of issuing of notice in terms of section 25 or 25 and 25 as it is made, and or the decisions thereupon by the appropriate government or clear suggestion of facts, and thereby public policy being laid out. The state government, before granting or refusing such permission, is not only required to comply with the provisions of the natural justice by giving the opportunity of hearing both the employees and workmen, but also required to assign the reasons in support of workmen, and also required to pass an order and report to the several factors laid down therein. One of the factors besides others which is required to be taken into the consideration of the appropriate government before grant of refusal of such permission in the interest of this workmen. The aforesaid provision being the imperative in character would prevail over the right of the parties to arrange the settlement. Such a settlement must be conformed to the statutory conditions laying down the public policy. A contract which may otherwise be void, however, must satisfy the text of the public policy and not only the terms of the aforesaid mentioned provisions of such terms of section 25 or 23 of the Indian Contract Act. The 16 para 16 also the same. Just bringing to the recapitulating what by this honorable court in previous case, the para number 4 we kindly be seen. Number 35 of the list of judgment. So the reference, one of the point is regarding settlement. For settlement, they have not yet given any findings regarding settlement. Number 2 point is settlement. Here number 4, my lord, the consequence of failure on part of the management to adhere the mandatory requirement of the provision of section 25 of the has been elaborately considered by Westmall Agro Furnish versus the Westmall Agro Furnish Workers Union to 2005-3 Supreme Court cases 224. In particular, the apex court has decided that the settlement arrived at between the management and the workmen would obviate the complaints with the provisions of section 25. Their lordships clarified the law in these but 15 months just already the same thing. And 16 also it has already been done. And in para 5 minutes, we can do it would be an opportunity time for the nation that the question arise issue of constitutionality of section 25 of the Act as being requested by the constitutional bench in Odisha Textile Steel Inspector, State of Odisha AR 2002, the Supreme Court case 702. In view of the outcome of the apex court in Westmall case, it is not necessary for us to go into the complexity details of the settlement. Allegedly arrived between the appellant and the respondent. The exposure of the law admits that no debate saying that regardless of any settlement, however, the management and its personnel. Failure to the fall of within the four corners of Section 25 of the ID Act will in the result result in the closure of an establishment illegal with the section reproduction of the workman would be entitled to receive all their annulments for the complete period. The statutory equivalent of statutory and capable of unfair labor practice of shifting the reward of the workman to earn livelihood. In these circumstances, current findings of the individual as well as the no inference by us. This is there. Here it clearly says there is a settlement in that reference. They say that settlement they have all workmen, 3 workmen are received. They cannot unless they got government approval. The government has rejected. They have gone to the High Court. Closure application has been rejected. I have produced all the documents and all the judgment are produced, my lord. The closure application has been rejected. Then they went to the petition. High Court has rejected. Then they went to division bench. The division bench has rejected and sent it to the government for reconsideration. Again, the government has reconsidered and they said that you are going to be a for only one not judgment. I give you my lord. I don't want to take it. It is a question of 650 poor workers, my lord. And we are unable since from 20 years we are fighting with this case. We are not getting justice. Only from your hand we have to get the justice. And we are confident that only because of your kindness, poor worker may get justice, my lord. Just I will bring to the kind notice, my lord. The judgment of Supreme Court in BPL case, my lord. BPL Limited, Sudhakar and others. Paragraph 70, last judgment, the last page. Here, there, interim order, interlocutory order, effective. Reference of the industrial dispute state by the interim order. Then it worked as a threshold for proceedings with the dispute. They cannot proceed with the dispute when there is a stay. There is a stay, my lord. When there is a stay, they cannot proceed with the case and still the stay is continued. The reference is there. Reference is not dismissed and the restitution was not dismissed. When that is pending, when the reference is pending and the stay is pending, they cannot proceed with the case. That is the law matter. In case number 220 of the judgment, this one, practice and procedure, interim or interlocutory order, effect if a pending proceedings, operation order is stayed, pending disposal of the main matter, such as an appeal or revision, held, include order does not get passed or waived out, but only remains suspended. In these cases, however, the order of presence was itself stayed and hence the tribunal had no jurisdiction to pass further order. This is the order. In page number 221, clearly says, Contempt of Court Act 1977, interim order passed by the High Court, staying the order of presence of an industrial dispute held in such case, any order passed by the tribunal on an application under the provision of section 33 is the management amount to contempt of court. If they pass any order, it amounts to contempt of court. This is the Supreme Court judgment, my lord. And my other submission, Your Honor, may kindly see the first judgment. This is the BP Maheshwari versus Delhi Administrative, my lord. It clearly says under Article 226, the Honorable has no jurisdiction to entertain the petition on interlocutory application. Your Lordship has given the judgment in this regard, and it clearly says that it cannot be given. That is the DB Maheshwari case in para number 1. I don't want to read, I don't want to take time. Another judgment, my lord, you may kindly see the page number 9. Taken India Limited versus others. 2006, 9 Supreme Court cases.
No, you said only 2 decisions. Thereafter, you are reading everything. What is this?
That last one, only 1 minute.
1 minute.
I don't know, 5 minutes. It's too small that you will.
See the watch first. It's 3:42, only 1 minute. Then you will sit down.
Now, para number 9 of this statement, Malad.
Which page?
Page 18 of this statement. We are of the view that the High Court should not have implemented with the increase of the labor code unless it was aware of the opinion that the conclusion of the labor code was no further, that it could not be reasonably supported. In our opinion, having regard to the fact of the case, they can't be that is very clear. And in another case.
No, that's all you said last decision. Now.
Because the reference is still pending. It has not been closed.
Are we saying it is closed? Are we saying?
No,
what all you are arguing, Mr. You understand? You said half an hour. It's already 3 hours 43 minutes. What is this? It can't go on like this. We have the power to stop you. It doesn't mean that we can withdraw that order, which permits you to appear party in person. We will say this right now. You will not be prevented from. You will be prevented from appearing if you behave.
I'm sorry.
Please behave. You said half an hour. It's already 14 minutes past half an hour. What is this? One after the other. Last judgment. Nothing beyond this.
That page number 20. Ina Bank versus Decade 211 15 Supreme Court cases. 290. It is well settled by this court that no writ should be advertised against the implements of the labor code or the industrial tribunal, if only when the final award is given, then the party should be allowed to challenge it if he is agreed.
That's all. Thank you. Yes, Mr. 5 minutes. Not beyond 5 minutes.
But I find the synopsis. Matter relates only towards the settlement took place. 379 workers took about 5 crores on the checks. But that was decided in IS6, the tribunal that passed an order that they should deposit it to the tribunal, the entire amount. Having not done that, because the tribunal said we close the reference if you do not deposit. That was challenged in 303 with the very same appellant. This honorable court upheld that order and said, except saying that 1 month's time is granted for depositing the amount. Now the tribunal comes to a conclusion they have not deposited. That's a first part of the order of the tribunal, which I did not challenge this. Where the tribunal came to a categorical conclusion that 379 workers, the amount which they have received under the settlement, they have not deposited. But strangely, the tribunal went one step ahead and said, I will decide for 188 other workers, which is not a part of the reference itself. That's why the reference is closely.
Thank
you. That one 10 workers are paid.
Thank you.
B group symbol 46.
We have a further hearing matter, Mr. Shetty, not today, after vacation. A short date can only be after vacation. We only have 10 working days. See what happens if an application for temporary injunction is argued for 1.5 hours. So then what can be done? When we are told what is a prima facie case, what is balance of convenience, what is irreparable injury, what can we do? Tell us. No, it's not possible. It's already the EPS corpus we are hearing. EPS corpus.
Huh? Unification on order, common order being passed to the Supreme Court judgment. In all the cases, Supreme Court has said each institution separate order has to be passed.
What he says is correct, or you want to argue? Then if you want to argue, we will.
Jurisdiction, if you can say
The committee has got jurisdiction in that is given because he appeared before the committee and said.
No, he said Supreme Court has said that separate orders has to be passed, whether it's correct or not.
Each one it has to be looked into.
That's what he's saying.
Each one has to be looked into. And
That's
if
what-
they do, it may just make one submission.
You have not made yourself clear. You not understanding.
I'll make myself clear. No, I got that.
You have to first convince, right? We always thought, no. We always thought that parallel communication is very effective, but in this case, it appears that you don't have any case because you have not been able to convince your. He says you are saying a common judgment. He is saying every case it has to be looked different. That means every case different order has been passed. This is what you are saying.
Common order has been passed.
Which judgment? Which judgment of the Supreme Court? You see which paragraph? See.
He did not submit to the jurisdiction of the committee. He said that I'm a Clean University. I am not.
You tell him. What is this? It's not a short issue. This is all. This volume is frightening, right? You are just telling us. We thought that we were getting into your trick. It's not like that. Once we will open the file, you will argue like that party in person. You tell him, no. Not agree. Not agree. Hey, Mr. Shetty.
His committee is issued a notice. He appeared before the committee and said,
No, he's saying that it has to go back, right?
He accepted that the committee has got jurisdiction and it is placed that for an order permission.
Why he would
for the committee
why he would give up that plea that committee has no jurisdiction? What presently is assailing the order that a common judgment could not have been passed in respect of all.
If he concedes that committee has got jurisdiction, then he can go back.
It's not that easy, Mr. Right. List after ensuing summer vacation. We can give you a date on 26th May, whatever. 26th May. 26th May. Give a synopsis. What is this? Short, 2 pages. And should take more than 5 minutes. If you take more than 5 minutes, then you don't have a case. Only those lawyers argue for hours together who do not have a case.
I take 3
Like
minutes to
what?
establish that committee has got jurisdiction.
He's saying that's what he's saying. That's what he's saying, Mr. Committee has jurisdiction, right? You are saying, no, you said committee has jurisdiction. Fine.
And
26 May. But he said that he wants a remand, so we don't know. He doesn't want a remand. He's after vacation. Very soon. So, Mr. Shetty, we'll see. At least before this vote, you have to be brief. If you take more than 5 minutes, it means you don't have a case, right? Only those people who put their case precisely in 5 minutes, they alone succeed. Because if you argue hours together, we are also human beings. We just listen whatever you are arguing from. So like this page, this paragraph, you keep on reading. That doesn't register. Always first 5 minutes are crucial. And with your experience, you should know this. Rest everything goes on. At that first 5 minutes, we tentatively make up the mind. And invariably it is there. It prevails. Thereafter, we hear for the sake of hearing the argument. People argue for days together. One case, one counsel argued 4.5 hours. What happened? Because law was against him, he lost. According to us, it could have been concluded in 5 minutes, not beyond that. He took interpretation of statutes about judgments. He was applying it to this thing, pleadings and judgments, interpretation of statutes, whole this thing, 3 compilation running into 700 pages. So
No, you should realize this. That's why we thought of telling you. So you have to be brief. If you have a good case, then you should be clear and brief.
Other hearings, number 47, Srimati Deepa J.
Well, it's most obliged. Yes. Your Lordship, I was showing Your Lordship the case law yesterday. Am I audible, my lords?
Yes, yes.
Yes, yes. Now, my lords, straight away, I would like Your Lordship's attention, my lords, to page 196. The judgment starts and we
have that, right?
Of the judgments, my lords, the judgments compilation. The court must again give the judgments compilation.
Everything considered. Yes.
Yes, my lords, the judgment compilation, this judgment at page 196.
How much time will you take, Mr. By the way? I mean, we thought that you are an outstation counsel. That's why we accommodated you.
My lords, by the watch, my lords, by the watch, 15-20 minutes. By the watch, 15-20 minutes.
Yes.
I know.
We have had a very tough day today, so really.
I know, my lords. I've been seeing since morning.
We have
my lords, this
1.5
judgment
hours
starts from.
tension, so we are really afraid today.
Yes. My lords, I'll be very fast, very fast.
There is other counsel.
Mr.
You are
Raghavan,
appealing,
I think.
right?
Yes. 196, my lords, the judgment starts. 296. Yes.
We don't want you to.
196,
like
my lords.
I mean, page
196, the judgment starts. This is 2019 7 SCC 311. Page 196, it starts. I will not take Your Lordship through the facts. I will just recite it in half a minute. The wife.
We don't want you to rush through, right? I mean, because who will write the judgment? We have to write and
Yes.
Which compilation?
Now he has given that compilation.
This compilation.
Yes, ma'am. Earlier.
No, just now, yesterday we had given to the judges. Yesterday the judges saw it.
Yesterday.
Yesterday.
Compilation.
Page 196, 2019 7 SCC 311. 196.
With counsel, we may tell you we have recently dealt with all these cases which you are reading in extenso. Our judgment has been upheld by the Supreme Court, SLP dismissed,
yes.
right?
Yes.
We have dealt with all this Yashita, Sahu, whatever you are telling us.
Yes. My lords, in this case,
we would recommend that please go through this judgment in writ petition High Court number 145 of 2019. This is
I had the occasion.
by the Supreme Court.
Yes. I had the occasion, my lords. In my case, the facts are different. This is a child was 10 years old. My lords, here, my lords, the child is only 3 years old. And my lords, the wife has invoked the jurisdiction of the US court. That is more important. This is the difference. This is the main difference.
Oh, all right. Yes.
195. 196, the judgment starts, my lords. 196. My lords, because Nitya Raghavan came first and then Yashita Sahu. I know, I've read Your Lordship. 196, it starts. 2019 7 SCC 311. And Your Lordship can straight away come to one fact of the thing, my lords. Your Lordship will have para 4 at page 202. Para 4 at page 202. The brief facts of the case are from the voluminous record that the appellants Lahari and respondent are parents of minor children. The appellant Lahari went to USA for a master's in ITNE and thereafter started working in US. She is a biomedical engineer. The respondent is only highly qualified and went to US ITNE and presently a cardiologist. Their marriage was organized in Hyderabad on ITNE. From the wedlock, son namely Arthil and daughter Nesa were born on ITNE and both are US citizens and hold US passports. The couple purchased a house in ITNE. They joined the son started going to a school and daughter ITNE. Both the children are there in the US from their birth. Social and cultural value of US was certainly embedded in both of them. This fact cannot be ruled out that something certainly went wrong in the relation went to extent that the appellant Lahari took a decision to file a petition for divorce and custody of the minor children back on Itne on the premise that there was a complete agreement. This she files a divorce petition in the US, and then, my lords, your lordship will have para 9 of this judgment. Para 9. I'll straight away come to para 9. At page 204. By the time the parties could reach a final consensus by the intervention of the trained conciliators who disputedly played a vital role, there was a sad demise in the maternal and grandmother of the appellant, and in providing strength and support, the appellant traveled to India with both the minor children on 23/3/2017 with return tickets for Itne, and within 20 days of coming of Hyderabad, where the family resides, she filed a petition in the family court on 12/4/2017. She comes on 23rd March and files the petition in the Hyderabad family court on 12/4/2017. This is the order passed by the Hyderabad family court restraining the husband. Then, my lords, straight away, I'll take your lordship to para 12. The husband filed a 711 in the family court saying that the family court has no jurisdiction. That was dismissed by the family court. And then the husband filed an appeal in the High Court as well as a habeas corpus writ petition, which is at para 13, my lords. Para 13. I need not lay. And then the High Court, by 2 judgments, allowed the habeas corpus and also allowed the family court appeal, saying that no jurisdiction with Indian family court and the children are to go back. Now, my lords, the findings of the Supreme Court are at page 216, para 30. My lords, I'll just read it fast. In the instance case, the facts on record clearly manifest that the parties were residing in US Itne and their marriage was solemnized in Hyderabad on this. Both the children were born in US on Itne and are US citizens with US passport. Notably, the appellant filed an application for divorce and custody of the minor children in the US court on Itne. An order came to be passed by the US court. Despite that interim order, the appellant came to India on Itne, and within 20 days, she filed an application on 12/4/2017 for custody of the minor children. And concealing an application for she did not disclose that an order came to be passed. In the given facts or circumstances, we find no difficulty in upholding the opinion of the High Court that the minor children were not ordinary residents of Hyderabad, India, as envisaged under Section 9.
We should appreciate if you tell us in what context you are reading paragraphs. I mean, then we can perhaps,
yes,
if you tell us that this court is an authority for proposition.
Yes.
If
This
you
is both the
read
propositions.
paragraph hurriedly, probably we won't be able to appreciate for what purpose you are relying, and then you will say, High Court heard in not appreciating my submission. So please,
Yes.
I mean, tell us for what proposition you are relying on, which decision, then read.
This
Otherwise,
is
if
both.
you read hurriedly, para 30 doesn't make any sense.
Yes. My purpose to show your lordship is that
What is this? What is this authority? What is this? This is an authority.
This authority is both on 2 points, on habeas corpus as well as on the ordinary residence of the minor children. They have allowed the habeas corpus also, and they have upheld the High Court order. They had 2 special leave petitions were filed in the Supreme Court, both challenging the orders 8th February and 9th February of the High Court of Hyderabad. 8th February order was upholding that that the family court did not have jurisdiction to deal with the guardianship case. And 9th February was the order repatriating the children back to US in a habeas corpus.
same judgment that SFC dismissed. Here also, this. With his father and grandfather, but he was alone working on this. There will be nobody to look after that. That means relatives, family. All these matters have to be discussed. Like if the boy was about 8 years. Here she's a small girl, 3.5 years. Yes.
Meloj, I showed Yashita Sahu yesterday. Yashita Sahu, the girl was 3 years old. There also they repatriated the daughter back to US, where the daughter was 3 years old, if your lordship would recall. Then, Meloj, in para 30, the Supreme Court holds that the High Court was right in upholding that the petition for custody of the minor children cannot go on in India because they are not ordinary residents of Hyderabad. That is para 30. Now, your lordship, I will also take your lordship to para 51 at page.
We are not disputing custody. The seat is not present. Whatever happens, 216. Yes.
Yes, Meloj, and again I reiterate here, the wife files the case of DV and takes the order first, and then she abandons US and comes to India. This is my case. So the wife has invoked the jurisdiction of US court, and now she cannot say, I will not abide by the orders of the US court. She cannot say that. That is the law they have laid down. That once you invoke the jurisdiction of a foreign court, then you cannot say that I will not abide. That is the principle of comity of courts. That is my proposition to your lordship to accept. And then your lordship, para 31 I was reading at page 216. Should I read that, Malod's paragraph with your lordship's permission?
Yes, sir.
Yes. In the given facts and circumstances, we find no difficulty in upholding the opinion of the High Court that the minor children, but not ordinary residents of Hyderabad, as envisaged under Section 9(1) of the Guardians and Wards Act, resultantly, the application for custody of minor children filed before the Family Court Hyderabad is rightly rejected by the High Court in exercise of powers under Order 7, Rule 11 CPC. Maloj, in my case also, the Family Court has dismissed their petition. Maloj, in my case also, the Family Court has dismissed the petition on 7/11. At the same time, when orders have been passed by the US court, Maloj, this is very important. Maloj, they para 31, Maloj, these 3 lines of para 31. At the same time, when orders have been passed by the US court, the parties cannot disregard the proceedings instituted before the US court, filed in the instance of the appellant who is supposed to have participated in those proceedings. Now, my lords, we can straight away come, after discussing the entire case law, lordships can come to para 51 at page 224. Para 51 at page 224. It's on bottom. Para 51. Can I read 51 minutes? The doctrine of comity of courts, intimate contact, orders passed by the foreign courts having jurisdiction in the matter regarding custody of the minor child, citizenship of the parents and the child cannot override the consideration of the best interest and welfare of the child, and that the direction to return the child to the foreign jurisdiction must not result in any physical, mental, psychological, or other harm to the child. This is the crux. Tomorrow, your lordship can refuse my habeas corpus by saying that the direction to repatriate the child is not in the interest because it is physically or psychologically causing harm to the child. As an officer of the court, I have to state the correct law to your lordship. So, but there has to be material on record to show that there is physical, mental, or psychological harm being caused to the child. That is the thing. Then the High Court can say, no, we will not exercise the jurisdiction under 226. And this, my lords, in this, they uphold the order of the High Court, and they say, yes, children should be repatriated to US. And my lords, in this case also, there were orders passed by the US court prior to the wife coming to India. Now, there is one judgment of the Supreme Court where, my lords, orders are passed after the child coming to India. That is also with regard to 3.5-year-old child, which is, my lords, at pages 37 to 47. This is 2010, 1 SCC 591. And I have next the High Court decision also, the division bench of the Delhi High Court. That time, my lords, it was authored by Justice Sanjay Kishan Kaul, as he then was. And this judgment has been authored by Justice Altamas Kabir at pages 37. If your lordship will have page 37, it is against the Delhi High Court division bench judgment. And in this case, the daughter's name was Alina Mittal. She was a 3-year-old daughter, and both the parents were Indian citizens, but the child was a UK citizen. It starts from page 37, my lords. And, my lords, 39, the first paragraph is the first 2 paragraphs are the facts. If your lordship will have page 39. And, my lords, just para 2 for a minute. This is one of those cases where a minor child below 4 years of age is the victim of the acrimony of 2 adults who were responsible for her birth. The appellant was married to the respondent herein on Itne, and respondent was already working in the UK. The parties set up their matrimonial home first in Scotland, then in England. A girl child who is now 3.5 years of age was born from the said marriage. The appellant is also obtained employment in UK, and both respondent number 1 and the appellant acquired the status of permanent residence of UK in Itne. And prior to the birth, being born in United, the child acquired British citizenship and was holder of the British passport, although her parents continued to hold Indian passports. So, my lords, even if the parents were holding Indian passports, after the entire judgment, my lords, your lordship will have page 46, para 33. Page 46, para 33. Page para 33, my lords, can I read? At page 46. It is evident from the aforesaid order that except for insisting that the minor be returned to its jurisdiction, the England court did not intend to separate the child from the appellant until a final decision was taken with regard to the custody. The ultimate decision in that regard has to be left to the English court, having regard to the nationality of the child and the fact that both parents had worked for gain in UK and had also acquired permanent resident status in the UK. And then, my lords, para 36. We are satisfied from the materials produced before us and the submissions made on behalf of the parties that the High Court did not commit any error in relying on the doctrine of comity of courts, since the question, what is in the interest of minor, still has to be considered by the UK court, and the interim order passed in the initiative is only of an interim nature with a view to return the child to the jurisdiction of the said court. Now, my lords, I had shown the latest pronouncement of the Supreme Court of Justice Khanna's order upholding the division bench judgment of the Hyderabad High Court. I have shown Yashita Sahu to your lordship. And, my lords, I had also shown the order of the 16th of March 2022. My submission is simple, my lords. I will just show 4 pages and I close my case. Just four documents I will show and I'll close my case now, because I have promised your lordship I will take not more than 20 minutes and I want to stand by my word.
We don't want to curtail.
Yes. Now, my lords, I had given that list of dates to your lordships yesterday. Now, my lords, in this case, the wife files a DV petition in the US court on 3rd of June 2021. And, my lords, if your lordship will have my writ petition. if your lordship will have my writ petition, page 59 is it starts, the order is obtained by the wife from the US court. So it is the wife who has invoked the jurisdiction of the US court. Page 59 of my writ petition. My lords, what I'll do is I will send across a convenience compilation also, so that for your lordship's convenience. Today, I know your lordships have to see all the paper books. That is very cumbersome. I will send a convenience compilation also. Your lordship will have page 59 of the writ petition. '59 of the writ petition.
59.
59, my lords, this is the order passed by the US court upon the petition filed by the wife.
The next.
Yes. If your lordship will see page 59, the order is dated 22. It shows a 6/22/21. My lords, the dates are written in US like this. It's 22nd of June 21. First the month comes, then the date comes, and then the year comes. If your lordship will see page 60, the next page. On the column number 2, my lords, petitioner is granted exclusive possession of the residence and respondent shall not enter or remain in the household located at Itne. This is in Chicago. This is a 3-bedroom house and the husband has been restrained from coming into the house. Then, my lords, the number 3, respondent is ordered.
Just you have to take. Oh, how easy it is, right? I mean, just a pro forma, the judge has to tick in that. How easy.
Yes, that's those are the orders passed by the court everywhere, my lords. These are called DV orders. Your lordship is absolutely right. The respondent is ordered to stay away from the petitioner. Then respondent is prohibited from entering at the family care. Then your lordship will see para 5 in 3, not to remove the minor daughter Zoya Samir Malika from the physical custody or care of the petitioner. So I was restrained from removing the daughter from her by the US court. And then, my lords, last at 7, I was even denied visitation of the child. And your lordship will see page 62-63 is a petition. Now, my lords, what happens is she makes a complaint to the police. The police investigates it, and the police narrative is at page 97 and 98 of this only. No? Yes. If your lordship will see page 96 of the same volume, the policeman goes to the house and makes a report of what has transpired in the house. Yes, this is one day before the filing of the DV case on 2nd of June. She says the 2nd of June is the incident. If your lordship will see page 96, para 2. I made contact with Hamsa, who was holding Zoya. Zoya is the daughter, at the front door of the residence. Zoya appeared in good health, did not appear upset, had no visible signs of injury. At the same time, Saba requested that ambulance respond to the residence. Saba related today that after Zoya returned home from daycare, she went into the bedroom in which Hamsa was working remotely. Saba told Hamsa to watch Zoya and placed her on the bed. Saba related that Hamsa became angry and began to yell at her. Saba stated that Hamsa closed the door of the bedroom and then she heard an intense noise and Zoya began to cry. Saba believed that Hamsa had done something to hurt Zoya. Hamsa then exited the bedroom and looked Saba's cell phone from her hand. Saba stated that she was attempting to record Hamsa and was considering calling the police. Hamsa then hit her twice in the lower back with closed fist, hit her in the right thigh with a closed fist, and grabbed her left hand very tightly. At the same time, Saba fled the residence and called DPBD using a neighbor's telephone. I spoke with Hamsa, who related the following. Hamsa stated that approximately, this is the husband's incident. Then, my lords, your lordship will have the, yes, my lords, straight away have page 98. And she was even taken to the hospital also, everything, and said that there's no injury, nothing. Your lordship will have, she's taken to the Lutheran General Hospital, page 98. On the top, Saba requested that both she and Zoya be transported to Lutheran General Hospital and had to be examined. I went to Lutheran General Hospital and spoke with staff who related the following. No signs of injury could be found on either Saba or Zoya. Page 98, Malons. On the top. The policeman goes to the hospital. Page 98 at the top. Your lordships have page 98?
Yes, yes.
Yes, yes.
Yes. Saba requested that both she and Zoya be transported to the hospital to be examined. I went to Lutheran General Hospital and spoke with staff who related the following. No signs of injury could be found on either Saba or Zoya. Hospital staff related that Saba told them that she and her husband had gotten into an argument about taking care of Zoya while standing in front of each other, arguing and passing Zoya back and forth. The argument escalated and both Saba and Hamsa began to push each other until Saba left the residence. Saba stated that she wanted to sign complaints against Hamsa. Hamsa was advised that he should find another accommodation for the evening. I advised Saba that I would not be placing Hamsa under arrest at this time. DSP has not. Then the matter was relegated to the Children's Authority. Well, they also investigate the case and they have also given a report at page. That the report is in rejoinder at page
309.
309. Your lordship may note the page. I don't want your lordship to be taken to the report. Page 309 of the rejoinder
Is for me.
is for me. 309 of the rejoinder. My lords may just make a note. And the report clearly exonerates me by the Children's Department also. And the wife report is also examined at page 358. 373. 309 and 373 are two reports which clearly exonerate me, my lords. 309 and 373. And my lords, I would just want to show 351. There's a doctor's report at 351 of the rejoinder. 351. I will just read it. It's only 3 lines. 351, the doctor's report of the rejoinder. Just volume 2, sorry. 351, volume 2 of the rejoinder. Just 3 lines or 4 lines, which will show the entire case by her is false. That there was some injury or whatever. 351. Investigator went to Lutheran General Hospital, Park Ridge, and spoke with physician Dr. Ebele Chinvuba. Dr. Chinvuba stated that she saw Zoya right when the EMTs brought her in and did not see any mark. I wrote on the discharge that Zoya was seen for a contusion because the mother said that there was a contusion, not because I saw it. No injuries were noted. Absolutely false complaint to the police, my lords, that the father had hurt the child. And there and then the child was taken to the hospital also. She tried to mislead the authorities, my lords, there. My lords, in India, this will amount to mental cruelty, entitling me for a divorce, filing a false complaint. But my lords, there they take it very seriously. They take the child to the doctor. The police will restrain me from coming into the house. And my lords, today, we are not divorced. I am giving an offer. I will give the 3-bedroom house to my wife and my child to stay there. They want me to stay there, I will stay. If they don't want me to stay, I will not even stay in the house. I am paying the mortgage of the house. And my lords, in spite of filing the divorce, I want my child and my wife back also. Because these are only egos. I have taken instruction from my client. He still wants the wife, and I will withdraw the divorce case if she comes back to the US. And she remains my legally wedded wife. So she will not be in any disadvantageous position, my lords. And now, my lords, she blames the police authorities for not conducting proper investigation. And that is at page 105 of her count of my writ petition. Page 105 of my writ petition. She writes an email to the detective saying not carry down right investigation. And this is the reason I'm coming back to India. This is the reason for leaving US, my lords. She blames the detective there for not carrying out the proper investigation. What is page 105? This is dated 17th July 21. Your lordship will have page 105. The wife writes an email to the detective who carried on page 105 of the writ petition. It's in my list of dates also, page 105. My lords, 105. Please note that while I was in Des Plaines, the police department could not carry out proper investigation of the domestic incident report reported by me, police report number itne, on 2nd June. Even the police investigation report prepared by Mike Schild was very defective and a mere formality and did neither any justice to the case nor arrived at any conclusion. I sent various emails to your police chief as well as deputy chief and met your deputy chief in person and also the office of the state attorney, but all proves fertile and failed to inspire confidence in me about my safety and my daughter's safety. Therefore, in the interest of our safety, I was compelled to return back to India, and we are safe in India now, which my husband very well knows. So, my lords, she is not safe in a country where the husband is ousted from the house on a mere allegation and everything is investigated the same day. My lords, in India, with due respect, my lords, if any incident like this is reported to the police comes to the house and says, "Ye Miyan Bibi ka jhagda hai, ye aap apne mein sultaiye." My lords, the police here, what will the police say when the police goes to the matrimonial home? They say, "Nahi, ye Miyan Bibi ka jhagda hai," unless there are injuries on the child or the wife. My lords, they always say, this is a small matrimonial dispute. Please resolve it on your own. There is no offense. My lords, these people take it very seriously. They go to even minutest of details. So, my lords, she can never say, and my lords, I showed it back to America also. She says, I read those emails to your lordship yesterday. And my lords, in 2018, I showed that email to your lordship that before going to US, she wrote an email because of that corona thing. She wrote, and 194 was that, which I showed to your lordship yesterday. And her own messages to the father that she says, "You love your daughter like hell," which I showed to your lordship, and daughter and the father have an excellent bond. And my lords, let me tell your lordship, the concept which we have today is, my lords, in the US, the children are in the primary care center because most of the couples are working. They go at 8 o'clock in the morning and 5 o'clock they are picked up from the chaise. What do you call it? Daycare. Crèche. In India, you call it a crèche. My lords, they are taken from the crèche, and on the weekends they have holidays and the children on the weekends are with the parents. My lords, there they have shared parenting orders in case of a dispute. What I am saying is, I am willing to have my wife and daughter back. My lords, today, this thing happened because of my father-in-law. Had not been the intervention of my father-in-law, everything would have gone off very well. Everything would have gone up very well. We both have lived together also, so no problems. Sometimes it's the external factors which make the marriage don't work. And today I'm saying again and again, I don't want a divorce. I want her back with the child, my lords. And both of us, even she wants to live in the house she lives, or I will take another and I'll give her a 3-bedroom house. I asked my client, I said, please inspire confidence in her. Because, my lords, it's the best for the child to have both the parents. In case they cannot resolve the disputes, they can stay separately. Because the child needs a father also, my lords. Gone are the days when they used to say that the mother are the primary caregivers. Gone are the days. Today, let me tell you, I'm also a father. We make more efforts to also see. We have to attend the parent-teacher meetings of the school also, my lords, as a father. And the mother makes sure that the father attends it, even how busy you are. So my lords, what I say is that fathers play equal role in that. And my lords, again, for reiteration, why the child should be deprived of the facilities of the US when the child is a US national? And last but not the least, what is the harm which is being caused to the child to go back to US, my lords, when everything has been investigated in detail? So, my lords, please allow my writ petition, send the child and the mother back. As per Yashita Sahu, you cannot direct the mother to go back, but they have bifurcated the decision in 2 parts. If the mother agrees to go, then there are the following directions. And if the mother doesn't agree to go, then the grandmother can take the child. The grandmother here, and the grandmother has undertaken that I'll also be there in the US to take care of my granddaughter also. Yes. And here also, my lords, the wife is working. Admittedly, she's working in.
Where is she undertaken?
Yes, I'll give an undertaking on affidavit. No problem at all. I'll give an undertaking on affidavit. In Yashita Sahu also, my lords, he gave an undertaking on affidavit. And the recent judgment in the from the Hyderabad High Court of Justice Khanna, Sanjeev Khanna of the Supreme Court, there also they have passed certain directions that the husband will return the money of this and this. I have no problem, my lords. I'll support everything. So, my lords, please allow my writ petition, my lords, and please repatriate the child, my lords. I'll be highly obliged.
Yes, we will hear you tomorrow, Mr. Laret. Yes,
my lord.
Laret. We'll hear you tomorrow, Mr. Raghavan. Tomorrow, Mr. Laret, counsel for the petitioner concluded his submission on account of paucity of time. Submissions of Laret senior counsel for respondent could not be heard. List tomorrow for further hearing.
If my learned friend's client is filing any affidavit, my lord, I would request that it should be filed and copy given to me so that I can get instructions.
Please supply a copy. Yes.
So that I can get instructions as to what my client wants to do.
Yes, sir. Things. You please. He has said 2 things, Mr. Raghavan. Hello.
Yes, my lord. Yes, my lord.
So you can this thing. He has said 2 things, that he is willing to make available a 3-bedroom house for your occupation in US in case you accompany, and otherwise he says that his mother is also willing to be with you in US and take care of the child.
Oh, whose mother? I don't know. Is he talking about
mother? Petitioner's mother. Petitioner's
mother. That I can tell you, Lordship's mother is a non-starter because his child has never been with the paternal grandmother.
And that is
That is the problem. That would be non-starter.
That's what he just now said. He will file an affidavit tomorrow.
I'll file an affidavit.
Yes,
I'll get it attested. And my lord, I say that we were living in a 3-bedroom house. I'm willing to give that when she comes. No problem.
I put it to my client, my lord. There are many things I want to say about the conduct of the petitioner.
All right.
File tomorrow.
Tomorrow. We'll take it. We'll take an email.
Serial number 48 is
yes, Mr. Tomorrow, what to do?
hardly tomorrow or day after,
Please,
whatever. Huh?
Any day convenient to the court.
Tomorrow, my lord.
Tomorrow.
Any day convenient to the court. Tomorrow or day after.
Day after. Day after. We'll see if it can. Day after, Mr.
May I just make one submission, my lord? I appear for the petitioners in the writ petition. My lord, today the matter was before the learned single judge, and the learned single judge has adjourned the writ petition to Friday, and he has observed that if in the event there is no. I'm grateful.
Tomorrow, 48 tomorrow. For the year. Yes.
Grateful.
Yep, you have to call so that we can adjust, right? And these two cases will go on tomorrow also.
49. For final reading, CH Mallan Road, Sri Ravi V.
Done for the parties list next week.
Number 50, Sri Amit Deshpande, Sri T.M. Nayak.
Next week.
51, Sri Srimati R. Radha, Sri Ambaji Ramendra.
Or next week. Mark the presence list next week.
52, Sri Natraj Bullard, Sri Suyog Dev.
Respondent, my lords.
Yes, both of you filed it. You also have to file, right? So, Mr.
Please, my lords.
Statement of assets and liabilities, you have
Please,
to file.
please,
How
my
much
lords.
time?
Lords, 2 weeks, my lords. May be taken up after vacation, my lords.
Learned counsel. All right. Learned counsel for the parties jointly pay for and are granted 2 weeks time to enable them to file statement of assets and liabilities. Just after ensuing summer vacation.
Today, Sri R. Hemant Raj, Sri S. Nagaraj.
What? Yes, yes. Ready. What can it be heard? Yes. Other side, who appears?
Yes, Nagaraj.
So, next week, Mr. Water, there's no time today. Mark the learning council for the applicant. List next week.
54, Sri Joseph Anthony.
A week, what week after next man? Because why are that's what you are not going out anywhere, right? Huh? Not possible, not possible. It has to go beyond vacation. Oh, but only next week, 3 days, Mr. Next week we have only 3 days, 11th, 12th, and 13th. We don't know. After. Yes. Public presence. Just after
list on what, 26 May? 26 May 2020.
Shri Ajay Kumar Patil, NKT, NK.
Tomorrow, no time. For parties, list next week.
Petitioner in this case, sir.
Yes. Or, of course. So what is it about, madam? Oh. After vacation, Mr.
Yes, Your Lordship.
Mark the presence 57 on account of paucity of time, the matter could not be heard. List after ensuing summer vacation.
I pray for the respondent in this matter, Your Lordship. May be taken up after vacation, Your Lordship.
Great counsel for respondent 58 praise for adjournment list after ensuing summer vacation. Yes. Not for parties list after ensuing summer vacation.
Lord, I appear for appellants in this matter, my lord. The request that the matter may be taken up after vacations itself, my lord.
Counsel for the appellant.
I appear for the respondent in this matter.
List after ensuing summer vacation. Mark her presence also.
Please, my lord.
61. We Purna Prasad here, government educate, CH-2 Kumar.
Tomorrow, it's a EPS corpus, right?
Doesn't come on.
So next week, what? Next week. None for the petitioner list next week.
62, Srimati HR Renka, Station Dasura.
We are appearing for the respondents, contesting response.
List after ensuing vacation.
Ensuing vacation. Would it be on 18th or 19th?
No, it's not far off. Only 10 working days are left, right? So
would it be on 18th or 19th? We'll take a chance.
Why 18th or 19th? Why? After vacation, whatever date you choose. Tell us which is after vacation, whatever date. 31st May. 31st.
Please, ma'am.
List on 31st May.
63, Sri Satish K, Sri Nishant Devi, Sri B.L. Sanjeev.
Yes. All right, if you are prepared to take chance, fine. Let it continue, Mr. Tomorrow in the list.
64, government educate, Sri Vivek Pallak.
With my lord's kindly, I appear for the petitioners in the connected matter.
You want to argue, right? You have to. Yes. So this is 64, right? Madam, so after vacation, right? List mark 64 list after ensuing summer vacation.
Well, it's the petitioners are all senior citizens, my lord, could be taken up before vacation.
1st June. 1st June 25.
Grateful, madam. My lords, I appear for requirement number 2, my lords.
Yes.
My lords, on the last occasion, the matter was adjourned for impleading Union of India, my lords. The petitioners have not taken any steps in that regard, my lords.
You are petitioner, right? No, you are
I appear for respondent number 2, my lords.
Let steps, if any, for impleading Union of India in terms of order dated 28/3/2020 to be taken within a week, list thereafter.
Much obliged, my lords.
Number 66, government educate, Sri Ganapati Egde.
Petition government advocate prays for adjournment list after ensuing summer vacation. 66.
I am the respondent in this case.
I'm appearing for the appellant in these matters, my lord. 67, 68, and 69.
Kindly may after vacation, man.
List after ensuing summer vacation.
Much obliged.
68, 69.
The Virupaksha PH, government advocate, the Ravi H.
List after ensuing summer vacation.
71, Station Pradeep Kumar, CM 9%. Is almost concluded and the matter is solved by an office statement delivered on 23rd March 2020.
What to do is not there tomorrow. Right. 71 list, let it be there tomorrow. Right.
32, Sri G.V. Sharad Gowda, Sri K. Keshamurthy.
List after ensuing summer vacation.
73, Sri Shukrasa Shantan Gowda.
For the appellant.
So after vacation, Mr.
Please, Mr.
73.
74, Sri Nayak V.A., Sri Srimati H.R. Renuka.
List after ensuing summer vacation.
25.
I'm the petitioner in the writ petitions, my lord.
We are for the respondent in the writ petitions, my lord. My lord, there is
Yes.
some degree of urgency, my lord. If my lord will kindly have it on Monday or Wednesday next week, my lord.
My lord, there is no urgency, my lord. May be posted after vacation, your lord.
My lord, the petitioner, my lord, is a credit rating agency. The decisions that investors make in the market will not depend on the ratings issued by the petitioner. Allegations made against the petitioner include that members of the business side of the
Mr. We have decided your application, right? For vacation of stay and all that.
Yes, ma'am.
Yes. So what is
Final
there
hearing.
now?
My lord,
Final hearing after vacation. There is no time this side of the vacation. Just after whatever date you want beyond vacation, tell us.
my lord, maybe had in the first week after vacation, my lord.
31st May. List on 31st May 2022.
Please, my lord.
Good. You want? You have to call it done, right?
Yes, ma'am.
This is what?
Yes.
3 cases will be repeated tomorrow. Then that EBS for right.
ಟೋಟಲ್ ಒಂದು 1000 ಏನು ಕೊಡಲ್ಲ ನಾಳೆ ನಾಳಿದ್ದು 2 ದಿನ ಮುಂಚೆ ಟೋಟಲ್ ಒಂದು ಎಸ್ ಕಡಿಮೆ ಆಗ್ತದೆ ಇವರು ಆರ್ಗ್ಯೂ ಮಾಡಿದಾಗ ಅನೌನ್ಸ್ಮೆಂಟ್ಗೆ ಅದು ಇದರಲ್ಲಿ ಇರ್ತೀನಿ
Hello. Hello, court officer, madam. Hello. Hello, sir. Hello.